why in this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. I'm Judge Capper. We're here for reviews first for people who have obligations they've been ordered to do. This is a check on that. So your name will be called if you're here for review. If you feel like you should have been called and weren't, go check in with the clerk's office. If you'd missed a hearing previously, you have to check in before they're going to know to call you because you're not on the docket today. Call the reviews.
Destiny Anderson, Donald Dickus, Justin Doyle, Holly Elkins, Ross Evelyn, Elise Faulkner, William Gulliver.
Destiny Anderson. She has been in Mahajan. She's not here today. Do you have any idea where she is?
She was supposed to be here.
Okay. It's a pretty good report, though, that you're giving. She hasn't done anything else on her case. So what I'm going to do, I'll give her a week before I'll issue a warrant, so she's got a week to get in here. And she needs to do, she's got community service and fines to pay too, so. Warrant will issue in 7 days if she hasn't appeared in that time frame.
Thank you.
Please let her know that.
Yes, sir.
Donald Dickus is 23-104 and 105. And he is
There.
He is here, and he's outpatient with Bethesda, and Taylor texted me that she was running late. So why don't you just have a seat, Mr. Dickus, and I'll recall you so I can get a report from Bethesda. Justin Doyle, 21-225.
Your Honor, if I may, I had a note that he was ordered on 9/15 to do some community service before his next hearing. He showed up on Blue Jeans on 9/15 and he was supposed to be here in person today.
Okay. He hasn't done anything on his case other than he did complete counseling, it looks like, at Serenity now, but he hasn't done anything else. So there will be a warrant issued for failure to appear today. Holly Elkins is
Yes.
here, 23-342 and 04179. And you did do some community service since your last hearing. You still have more to do. And do you have a payment on your fines today?
Tuesday I will.
Okay. I'm going to set, does it matter if it's in Mondays or Fridays for you?
No.
November 20th, which is a Monday.
Okay, thank you.
November 20th is your next hearing at 9 o'clock.
Okay, thanks.
Ross Kaplan?
Yes, sir.
It's 19-182. Okay, you just have to finish your community service. I'm showing you go 3 more days.
Yes, sir.
Your Honor, if I may, he did come in one day last week to do community service, but he came in late,
Okay.
so I did not let him know.
All right, how was your turnout Saturday?
I had 10 people show up.
Great. Okay. Get your 3 days done, you're finished.
Okay.
November 20th is your next hearing. Get it done before then, you don't have to come back.
All right, thank you.
Denise Faulkner. She has been at Hometown Recovery. She is still at Hometown Recovery.
I don't have a printout report right now, but I can get you one. But she is compliant.
Okay. Do you have any payment on your fines today?
Yes, sir.
How much?
$10.
Okay. Are you working?
Yes, sir. 2 jobs.
Mondays or Fridays better?
It doesn't matter.
I'll make it December 1st for you. That's a
Right.
Friday.
Yes, sir.
December 1st, 9 o'clock.
Thank you.
You're welcome. See the clerk to make your payment. William Galt, 0972.
Your Honor, Mr. Gall's been discharged from our services.
Okay. And he hasn't appeared, and he still has things left to do, so there'll be a warrant issued for failure to appear.
Ransom Johnson, Chase Lewis, Jennifer Losi, Michael Martin, Larry Pierce, Stephanie Plumley.
Chase Lewis is here, 141065. Just have to pay off your obligations. You've been making regular payments. Do you have a payment today?
Yes, sir, I paid 25 online.
Okay. November 20th is your next hearing,
All right, thank you.
9 o'clock. Branson Johnson, 21795. Hasn't appeared, hasn't finished. Gets a warrant for not appearing today. Jennifer Losi, 220262.
Sure.
That's something for me to look at.
And this is where I keep my check.
Okay, so now who's this Cassie Gilbert? Is that who you're?
That is my counselor now.
Okay. Well, the only thing I'm showing that you've got left to do is the driver intervention program.
I understand that, sir. I've recently had to quit my job because they was trying to take my check from me. That's what these 2 papers was I was showing you.
Okay.
Can I just go do the 3 days in jail?
I don't want you to do that. I'd rather, you can't afford the driver intervention program, is that what you're telling me?
Yes, sir.
Okay, I want you to go do a drug screen and maybe I'll come up with a diversion program for you. So go do the drug screen. Michael Martin, 22163 and 19,2006. Michael Martin's not here and he has things left to do. He's supposed to be, is there anyone here from Mid-Degrees?
He's been gone from our facility for about 2 weeks now. He
Okay.
went AMA.
Can I get a report on that? I don't think I've got a report. He'll get a warrant for failure to appear and for leaving inpatient program. Larry Pierce, 220894. Hasn't done anything on his case, so he gets a warrant. Stephanie Plumley is here, 22584. Okay, you have community service to do.
Yes, sir. I start that Friday
Okay,
with Leslie Chapman.
and fines and court costs to pay.
Right.
Are you going to pay anything today?
Yeah,
How much are you going to pay?
20.
Okay. payment with the clerk. November 27th will be your next hearing. November 27th, 9 o'clock.
Donald Porter, Danella Smith, Christopher Thomas, Stephen Watts, Jacob A. Williams.
Porter is here.
Yeah,
Back to your knee.
I was in a car wreck. And then it got affected, I've been on a ventilator for a few days too.
Okay. You've done a lot of extra community service toward your funds.
Yeah, I showed up Saturday to let Mom, but I was a little late, and couldn't, so I had to go to the village and work.
I'm going to let you work off your costs too.
Okay.
Okay, I'll consider this when we get everything worked down, so. I'll set your next hearing for November 20th.
Okay, thank you.
You're welcome. Donnell Smith, 163387. She hasn't finished and she didn't appear, so this will be a warrant issued. Christopher Thomas, 23285. So Thomas is at ARC.
Yeah, yes, Your Honor. He's the client I texted you about last week. We're getting at a bit of an inflection point here if he doesn't get compliant.
Okay.
I've been homeless and I haven't really had a way to get there. I'm living in a shed right now. I don't have heat or a way to shower. And my mom is the only person who can get me to and from. I don't have a car. I'm trying to get a job.
Where's the shelter you're staying in?
It's just like it's not a shelter. It's like a little building outside of my friend's house.
Oh, so I
Yeah.
thought you were staying in some kind of
Yeah,
public
no,
assistance.
no.
Where's that located? Where are you?
That's in Greenup. In
It's
Greenup,
where?
Greenup County.
Okay. Well, maybe he needs inpatient. I mean, can we get him in an
We
inpatient
could,
curve?
yes. I'll have to reassess him and see what
Once you
we
go talk, that's, takes care of your housing problem too, and your treatment problem. So I'll recall you after you talked about that.
Your Honor, if I may, this is Christopher Thomas.
It is?
He was ordered on 9/11 to have some community service done for his next hearing. He has not showed up yet.
Okay. Another reason to go inpatient. Because the other alternative could be jail. So go talk and come back and we'll see if we get a plan together.
Thank you, Your Honor.
Stephen Watts, 23737. Hasn't finished, has done some things, but not finished, and hasn't appeared today, so it'll be a warrant. A lot of people not showing up today.
Mr. Watkins here Saturday.
Was it? Jacob Williams is here, 22806-807. Got a report from RRS. Okay, it's a good report. You still have community service to do.
Yeah, I was going to do that over the weekend, but my grandma ended up in hospice, and I went to go see her. So
Okay.
I'll do it this
Sorry about
weekend.
All right, I'll set your next hearing for November 27th.
Thank you, Your Honor.
You're welcome. Keep up the good work.
Thank you.
Thank you, Your Honor.
Okay, that finishes reviews. We're going to start arraignments now. Arraignment is what the hearings call for someone on a first appearance, or if you have a warrant or got something happen on your old case and you're coming back court on that, you're going to get called with the arraignments. When your name's called, come up to the table to the right, just like the prior folks did. Stand there. I'm going to order your charge with you. You have a right to remain silent. You're not required to say anything, but if you do say things, what you say is all on the record. So if you get up and admit something about your case, that can be used by the prosecutor against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove a charge against you beyond a reasonable doubt. If you decide to enter guilty or no contest, you're just waiving those rights that I explained to you. You should not waive your rights and enter a guilty or no contest plea if you don't understand what's happening, if you're confused, if you want to talk to a lawyer, or if you want a trial. You should enter a not guilty plea. That's always the safest plea you can enter. Call the first case.
State of Ohio versus Stephen T. Wells, case number TRD 2030-1486, A and B.
Sir, are you Stephen T. Wells?
Yes, sir.
Mr. Wells, it's alleged that on October the 11th, 11:55, which would be a.m., 11:55 a.m., in Fayette Township, you were driving a vehicle with a suspended license. This is not jailable. It's what's called an unclassified misdemeanor. Maximum penalty is 500 hours community service, $1,000 fine, and that you failed to maintain a sure clear distance ahead, which usually means you hit something. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand the charges?
I do. I have a question. I was in here, Chris Daughter was my lawyer, and I had a...
He's here today. You want to talk to him?
Well, he was my lawyer for that, what that is. I had a paper signed by you saying I was allowed to drive, and they said, and I asked Chris about it, he said I could drive until I got my license.
Okay. He's here, so this is Mr. Wells. He's got some new charges, including driving without a license. I think he wanted to talk to you about it, so we'll let you do that, and we'll recall it.
Okay, thanks, Judge. You said it was an arraignment today?
It's arraignment.
Okay. I'll holler at you in just a second.
State of Ohio versus Bradford L. Lusher, case number TRC 213173, A, B, C, and D.
And sir, you're Bradford Lusher?
Yes, Your Honor.
Mr. Lusher, it's alleged you had a review hearing on October the 2nd, which was 2 weeks ago, that you didn't appear for.
Yes, Your Honor.
Do you admit or deny you missed that hearing?
I missed it, Your Honor.
Do you have an explanation for missing?
I don't have a license yet, and everything's a hardship. I got to depend on a bicycle or car and asking other people for rides.
Okay, where do you live? Piketon? Do you live in Piketon?
Right now, I'm staying temporary in a camper out behind my dad's house out by Beach Fork campground. But
Okay.
Piketon's where I need to return to. That's where my work and everything. That's what my hardship is I don't want to go all the way back up there and then have a court date just 2 or 3 weeks later. I was wondering maybe my next review, Your Honor, if maybe we could make that next court date maybe 2 or maybe 3 months. I've got time to get back to reestablishing my job and getting my wealth built back up and getting everything that you need me to do. Because right now
Well, you need to do some community service. You're going to have to be here to do that.
Yes, sir.
Are you working now? You're not working?
No, sir. That's the thing is I've got RKJ and Piketon wants me to come right back to work. And they sent a truck for me the day after I missed my court date. And I had the time I missed my court date that I had to make things right with you before I went all the way back up there. It's like 80 miles. And I wouldn't have made it today if I wouldn't have asked if my father would have gave me a ride, because riding a bicycle or walking, there's no way. It's over 10 miles. Of course, I know it's not that hard to make a 10-mile trip, but it's just.
Well, if the alternative is going to jail, I mean,
Makes me
you gotta
want-
get here. You gotta figure out how to get here.
Yes, sir, it just.
You got $50 and you've got 5 days of community service is all you've got left to do. And probably the driver intervention program too, you're supposed to do that.
Yeah, you know, I paid for that, I paid cash, and they stalled me out at the Holiday Inn at the counter until I was like 15 minutes late. I went in there and they made me leave because I was 15 minutes late. And I paid, it was like $500 cash. I mean, I had the money then, now, you know, it
Is
used
that
to.
down in Sauter County or
Yes, sir, that was not Sauter, but Ironton, I think.
in Ironton?
Yes, sir, it was the Holiday Inn Express off of 93.
Yeah,
And,
well, that company's out of business now too. They're not even doing that.
I could understand why.
Not the hotel, the Spectrum that put on the program. They're not
Yes,
even
sir.
in business anymore.
And then the one in Sauter County, I've called, and they wanted a number, but they never called me back. And so the one in Columbus was the one I was thinking of.
You can go to any one that's approved by the state of Ohio, and I'm
Yes.
sure a lot of them in Columbus.
I'd say so. I talked to one, and they spoke to me, and it was only like $350 as opposed to the $500. But
Well, you gotta get this done. I'll withdraw the warrant, because you've paid almost all of your fine. I'll withdraw the warrant, I'm gonna give, this has been since 2021, so this
Yes,
is
sir.
over 2 years.
I should have had all my fines should be completely paid.
Well, you've got a warrant fee now for missing,
Oh,
$50.
does that cost money?
Yeah, $50.
Oh, I didn't know. That'll teach me to be late, though, that's for sure.
That's actually a bargain, because the clerks have to prepare a warrant, they've got to send it to the sheriff's office, then they've got to broadcast it to all the police agencies. Then when you show up and they withdraw it, they got to, it's a lot of work,
processing.
man. When people don't show up, it's a pain in the hind end and a lot of work.
Yes, sir, I understand.
$50 is not even probably cover all the costs.
No, it's a major hardship for me, too. I mean, I used to have money in the bank.
It's supposed to be somewhat of a hardship. Okay, I'll set your next hearing for November 27th. That gives you past Thanksgiving. You just gotta buckle down and get some of this stuff done. Get over here and get 5 days done and get your dip school done. You can quit coming to these things.
Yes, sir, Your Honor.
Okay,
And you say it's
that's all.
November the 24th?
7th, November 27th, the Monday after Thanksgiving.
All righty.
Okay, good luck, get it done.
Yes, sir, thank you, Your Honor.
You're welcome.
State of Ohio recalls Jennifer Losi, case number TRC 22-262, A and B.
Okay, what I'm gonna let you do is extra 30 hours community service instead of going to the jail or doing the 3-day school.
Yes.
So let's do a judgment entry to that effect. And I'll set your next hearing for December 1st to give you plenty of time to get it done. If you get it done, you don't have to come back. That's all you got left to do.
All right, thank you, Your Honor.
You're welcome. Okay. We're going to start some pre-trials. There's still some arraignment paperwork being done, and there's some people at the jail we have to do, but the jail's not ready. So we'll start with the pre-trials.
State of Ohio versus Eric L. Ferris, case number TRC 23-1183. Mr. Delong.
Eric Ferris is Mr. Daughter's client. Good morning.
How are you? Who is this? Your Honor, I've got one of your files here. It's for Was on.
Okay.
You put that on pre-trial, so then we'll just.
Yes.
What's this case?
Ferris?
Yeah, what is it? So he ran a tweet. On the motion? Got plenty of access. On the motion.
Judge, can I grab my schedule real quick?
Yes.
Judge, I've talked to Mr. Hill briefly about some issues that we think are present in this case. It may resolve it, but Mr. Hill wants me to flesh those issues out in a pleading. If we can have another pretrial rather than setting it for a motion hearing, I think that would be best, if that's okay with you.
Okay, are you going to file the motion though, so we pre-trial the motion?
Before the pretrial, so that Mr. Hill can look at it, yes. It shouldn't take me very long.
All right, let's,
I'm going to be gone, Judge, from the 3rd through the 13th of November.
okay, how about the 17th? 17th or 20th?
Let's see. Let's try the 7th. Can we do the 17th?
All right, the pretrial motion on November 17th at 10 o'clock.
Thank you, Judge.
As soon as continuance increase.
So, Tim,
What's the date of that, Your Honor?
November 17th. Pretrial motion.
Can you hang out with this man? I'll talk to you in a second.
State of Ohio recall Stephen P. Wells, case number TRC 231486 A and B.
Mr. DeWaters, case is set for arraignment today.
Yeah. You remember that? That's your license suspended? Yeah, I wouldn't mind getting back till November.
Mr. DeWater, on that last case, Eric Ferris, can we change that? We're actually have a jury trial on the 17th, so I'd like to change that.
20th?
The 20th?
Yeah, it's fine.
Okay, let's change it to November 20th.
And is a motion going to be filed on that? Is that what you're doing?
I'll do it before, I'll do it at least a week before the hearing so you can look at it. The issue is pretty limited in that case.
How do you wish to plead on Mr. Wells?
Judge, I think Mr. Wells wants to enter a not guilty plea. He but believed that he had driving privileges and that would have applied in this case. I don't have my old file, so I don't have any idea if any of that's accurate or not, but I'll look.
Okay, so enter a not guilty plea.
Yes.
When you want to say that is.
You want to do it next Monday? I mean, it shouldn't take long to resolve it.
It'll be the 28th pretrial that day.
Oh, you want to do it on the 20th of November? That's fine with me
Yeah.
too. Okay.
All right. November 20th for pretrial, 10 o'clock.
State of Ohio versus Jonathan R. Mays, case number CRB 23518.
This is Mr. DeWater's case for pretrial.
Is Joshua Hay here?
Didn't he have a case in common pleas?
He does, and he was the defendant and Mr. Mays was the victim in that. That case has been concluded, I believe, in common pleas court. And I was hoping, since he was on the docket here today, to have a chance to talk to him about this situation, to get his feelings on it. So he's not here, and I don't know whether his case has been called yet or whether it's even scheduled for yet.
He's on the docket as a defendant also?
He's on the docket for some reason, I've been told.
Judge, I represented him in common pleas, and that matter's been concluded.
Okay, I don't think he actually is on our docket.
Joshua Hay, 21 CRB 324, under sentencing.
Judge, it's Mr. Morford's.
Excuse me, he is on our docket for sentencing today.
So, but I don't know whether his case has been called yet or not.
Yeah, it's not.
So maybe he will show up.
And Your Honor, one thing, I did speak briefly with Mr. Morford, who represented the complaining party in this case. It's Mr. Morford's understanding that his client was agreeable as part of that whole resolution that this would be dismissed. That's what Mr.
And it may be,
tells me.
but I don't have word of that yet, and I would like to be able to speak with him in order to be able to confirm that. So, seeing how he's on the docket today, I don't know if it's possible to...
Yeah, do you want to recall it and see if we can get a hold of him?
Sure.
Okay, this case will be recalled.
State of Ohio versus Jill Moore, case number CRB 23416, CRB 23390. Jill Moore.
She's not.
Check in.
Yeah, she's not here, Judge. You gave her permission at the last hearing not to appear today.
Correct, it's the cost will pay.
Yes.
Then those are all...
It looks like. Yes, cost on 23-416 has been paid. That was the agreement. So, state's still willing to dismiss it, and that also was 23-390 was going to be dismissed also.
And, Your Honor, the victim says there have been no further problems. So
Okay, so both matters are dismissed.
Thank you, Judge.
State of Ohio versus Jeff Porter, case number TRC 231143, A and B.
Judge, we received discovery on this case. Actually, I received discovery, paper discovery, quite a couple weeks ago. I didn't realize that the video had been provided. The prosecutor's office was kind enough to provide that to me again on Friday when I called to inquire. So we need to go through that. I expect there'll be a suppression issue with this case, but I don't know yet until I look at it. Can we have a pretrial on this on the 20th? Yes. And I don't know that I'll have the motion filed yet. I hope to by that day, but I'll try.
November 20th for pretrial on motion to suppress.
Thank you, Judge.
You're welcome.
State of Ohio versus Glenn F. Church, Jr., case number CRB 23379.
Mr. Permeen's case. My notes were this would be dismissed if there was no further problems and the costs were paid.
Your Honor, I believe there hadn't been any further problems, and Mr. Church indicates he can pay the cost today. There was a divorce filed in this matter. The parties are now, that has since been dismissed, and the parties have reconciled and are back together. So I presume there haven't been any further problems.
Mr. Hill?
The last indication we have is there have been no further problems, and we've reached out to her a couple of times, 3 times, and just left voicemails for her to call, and she has not called. So our assumption is that there's no problems.
Okay, see the clerk, pay the cost in case we dismiss.
Yes, sir. Thank you.
Clerk is to the right, moving forward.
State of Ohio versus Leah Maynard, case number TRC 23671 A and B.
Mr. Kermees' case, pre-trial motion.
May we approach, Your Honor?
Yes. Has there been a motion?
Time issue, most of that filed without leaving the form to file later, but this will play on strict rules based
We can. I actually didn't know that was the rule. I had no problem with that. Start. It's never been raised just up to now, so we can start. Okay. I mean, do you want to raise that objection now, or on this case? What do you think you should? Okay. All right, I'm ignorant on that portion of the timeline.
It's 12, the motion day.
So henceforth. Okay. All right, the prosecutor is going to not object to the filing of a motion out of rule. So the motion will be filed in pre-trial on October 30th or thereafter. Are you available on the 30th?
I believe so, Your Honor. Let me just briefly double check. I'm not on the 30th, but I am on the 3rd.
How about the 3rd is actually pretty bad. How about sometime after that. 6th,
Can't do the 6th, I'm in hearing, but I am available the 10th.
well, the 9th. The 10th is actually Veterans Day. We're having court on the 9th.
Sorry, Your Honor.
We're having court on the 9th because the 10th is Veterans Day.
Oh, okay. I am available.
Okay, November 9 for pretrial motion.
Okay. Thank you, Your Honor.
You're welcome.
State of Ohio versus Aaron Sloan, case number CRA 23368A and B, CRB 23369, and TRC 23750A and B. Aaron Sloan.
Aaron Sloan is Mr. Workman's case.
Yeah, ma'am.
Yes. Well, according to a letter from Mark, she's compliant with treatment, but she's not here today. Any idea where she is?
No, Judge, I haven't heard from her.
She still has a felony pending.
If you give me a week, let me try to get a hold of her.
Sorry, Your Honor, I'm
idea
still back
about-
there, Mr. Brad Thomas. She's been compliant, I'm not sure why she's in here. I have her phone number, I can try to get in touch with her and tell her to get down here.
Okay, why don't we do that? Once you get a hold of her,
Yep.
we'll recall this later in the docket.
Thank you.
Thank you, Your Honor.
State of Ohio versus Derek C. Willis, case number TRC 20168 B, C, and D, TRC 14901A and B. This is down to Mr. Cummings' case or Holt, I'm not sure which you're on. Derek Willis.
I've had no contact with Mr. Willis. I represented him once in the past, but other than that, I've had no contact with him.
I have a Mr. Willis down in the common police court named Derek. I don't know if it's the same person or not.
These are two cases that he's already pled on. He actually should be on the sentencing docket because he has a bond up. He has a bond through Peach Bond.
Birthday in 1976.
Yes, August 27th.
Yeah, same guy.
You're representing the common please?
Yeah, I'll try to call.
Okay, I'll recall this.
State of Ohio versus Megan C. Ison, case number CRB 23623. This is an arraignment.
Ma'am, are you Megan Ison?
Yes.
Ms. Ison, were you here when I explained the rights that defendants have? Do you have questions about that before I go ahead with the charge? The charge against you is theft. It allowed the complaint that's been filed. Have you received a copy of this complaint?
Yes.
The complaint alleges that at Fayette Township, on October the 15th of this year, you tried to deprive Walmart of property without their consent. That's a theft charge. Maximum penalty is 6 months in jail, $1,000 fine. You understand this charge?
Yes.
How do you wish to plead to the charge?
No contest.
No contest means you don't want to fight it. You agree you can be found guilty without a trial, without you having a lawyer. If, after I hear what evidence the state says it has against you, if I think that's enough legally for a conviction that I can find you guilty without a trial and lawyer. You understand that?
Yeah.
That's what you want to do?
Can I change it to not guilty?
You can. Do you want a lawyer appointed to represent you?
Yes.
Do you have a job?
No.
You have no income?
No.
I'll appoint Mr. Morford to represent you. Entering a not guilty plea. You posted a bond. So your bonds continued that you posted. And then we need to set a pretrial. And I'm looking at probably in November the 9th, 13th, or 20th.
What was the first date you said, Joe?
9th, which is a Thursday.
I was going to say, I wanted to, that's why I asked you, because I wanted to
The
make
10th
sure.
is a holiday.
I'm good on the 9th.
Okay. November the 9th will be the next hearing for our pretrial at 10 o'clock. Her bond is continued and not guilty plea is entered.
State of Ohio versus Chanel Atkins, case number CRB 23516, A and B. You'd like the pretrial charge, Mr. Thompson.
Chanel Atkins is set for pretrial today. Mr. Thompson.
Chanel did not check in.
Any idea where Miss Atkins is?
Attempted contact, but
There'll be a warrant issued for failure to appear.
is that today or is that 7 days?
7 days.
State of Ohio versus Austin L. Carmen, case number CRB 22254, CRB 20897.
This is Mr. Thompson's case set for pretrial.
He's over here. He's the same. That's one of the contracts. No, that's one stuff. That's one. Yeah, that's hard flip there.
Right. Right. There's just this one. Okay. Okay. Your Honor, to please the court, after much negotiation and discussion about this case, we've made an offer, after having spoken to the victim, making sure that the victim understood and was agreeable to this, we would offer for a plea of guilty a suspended jail sentence of 10 days, a period of probation. We would not take any position on the amount of the fine or other sanctions.
Okay, well, I only agree to that if Mr. Carmen takes care of his prior obligations. He had a disorderly conduct December 28, 2020, which he's never done anything on. So if he wants this deal, he's got to take care of that. I'm not going to, might as well
The only thing to do on that
order,
is community service and fines.
order him to do 5,000 hours of community service, because he's not going to do it. He's not going to do anything he's ordered to do, from looking at his last case.
That's what he done.
So what is still remaining for him to
He's
do?
got 2 days of community service,
It's
and
done.
$285 in fines and court costs.
What are the fines?
They should be close to paid off.
208.
I've been paying them. I've been in community service. I've done 3 years on the road too.
If we can hold that offer in advance, maybe it's best that we just continue it for a month.
Just continue it a month and get out here and get stuff done that you were ordered to do 3 years ago.
That's what I done.
Okay, hold up. I haven't given you a date yet. You're not dismissed. So in November, Mr. Thompson, what's your schedule like?
The 20th would be okay, if that's fine with you.
November 20th will be the next pretrial, 10 o'clock. You can do community service any day here at the court except Sundays or a holiday. And you can work off your fines if you can't pay them.
John, on my use here Saturday.
Okay, so you will get credit for that.
Thank you.
You're welcome.
State of Ohio versus Justin E. Stapleton, case number CRB 23359.
This is set for pretrial today, is Mr. Thompson's case.
We can't come to a resolution of this, so if we could set it for a trial, and we would suggest November 13th.
The 13th of November?
Is that okay?
Yes.
Okay.
I'll set it at noon for trial.
Maybe a pre-trial for first thing in the morning?
We'll be able to talk about it in the morning.
Okay.
Okay, so let's be here at 10 then. So parties are ordered to be here at 10 o'clock. We'll try it at noon if it's not resolved.
State of Ohio versus Adam C. Reynolds, case number CRB 23400 and CRB 23448. Your Honor, I have Mr. Thompson, I also have a picture of Mr. Steyer, including Mr. Steyer, not here, I'm not sure.
I just texted him, I don't know what's going on, let's see.
He is on the docket, I don't know.
He texted me and said he was going to be here as soon as he could.
Want to just recall because apparently there's a
Well,
companion case?
I have the aggravated menacing, and I believe the prosecution wants to continue it until the open dumping is totally taken care of.
Who is
So,
this?
this is Adam Reynolds.
Your Honor, Mr. Reynolds, according to our enforcement officer, has done what was asked of him so far. The job's not done, but he has, I guess, gathered everything in a pile like it was asked to do, and that's the step before actually, I guess, getting dumpsters in there or something. He's also taken an additional step of trying to remove an old mobile home or trailer or something from the property.
It wasn't mine, it was there when I bought the property.
So he's working on that too. So we're okay with the continuance. Now, there's also the issue of the aggravated menacing, which we're not necessarily just agreeing to not pursue. However, we want to see this other done. I think it would go a long way with the neighbors. And also, I don't know if Mr. Reynolds is still living at the property or plans to move or has any intentions like that.
No, I've never really lived there. I got an RV up there that I stay in sometimes, just for like a weekend away or whatever. But the neighbors have been hard to live next to say the least. They got 5 dogs that bite. They attack you on your own property. They don't care at all. They don't do nothing about it. They let them go every time you pull in the driveway. You can't get out of your car up and jump on your car or attacking you. And nobody's ever said or done anything about that.
Well, you can call.
I have. They told me they didn't want to get in the middle of my dispute.
Call Mr. Thompson. Don't call me. People don't do their job, I don't know what I can tell you. The dog warden's supposed to be in charge of that.
Yep. So you have this pretty much cleaned up in a month? Opened up and you'll have that.
So come back in a month?
Yes.
The 20th? November 20th will be the next hearing.
You've got
both cases.
Got a deal worked out with the local trash company too. They're gonna come by and pick up all the stuff that everybody left.
Okay. Sounds like you're making progress on it, so maybe that one will go away, hopefully.
Thank you.
State of Ohio versus Lindsay T. Miller, case number CRB 23625.
Okay, this is an arraignment hearing. Lindsay Miller, is that you, ma'am?
Yes, sir.
The bailiff's handing you a copy of the charge.
Okay.
Were you here when I explained the rights of the defendants?
Yes.
Do you have any questions about that?
No.
The charge against you is assault. It's case number 23625. It alleges that on October the 14th of 2023 in Perry Township, you knowingly caused or tried to cause physical harm to Lathan Hall. That's an assault charge. Maximum penalty for that is 6 months in jail, $1,000 fine. You understand the charge?
Yes, sir.
And you do understand your rights?
Yes, sir.
How do you plead to this charge?
Not guilty.
Do you want to be considered for a court-appointed lawyer?
Yes, sir.
Are you working?
No, sir.
Do you have no income at all?
No, sir.
I'll appoint Mr. Thompson to represent you.
Okay.
We're requesting a protection order, Your Honor.
Okay, is it a problem, ma'am, for you to stay away from Lathan Hall?
We actually live in the same apartment complex.
Okay. Well, that makes it harder, but I'm going to order you to minimize contact. So you see her, you go the other way, you go in your apartment, and she comes around you.
I have no contact with her, sir.
You retreat, call the police or whatever if she's being aggressive toward you. But my goal is there not to be an allegation that something else happens. I just want things to cool off.
Oh, I completely understand. Thank you.
I'm going to let you sign a signature bond. $1,000 signature bond. Be back here.
Now what is this for?
Just stay.
So even though that she's not here today, that has nothing to do with anything?
I'll give you a copy and I'll talk to you about this. Okay, so I'm going to be able to talk to you about that.
Mr. Thompson, how about the 13th of November?
Okay.
Is that good?
Yep.
November 13 will be the pre-call at 10 o'clock. November 13.
What's your phone number?
Oh, no, that's the startup, sorry. 570 0936. Thank you.
State of Ohio versus Stephen Stapleton Jr., case number CRB 23428. Mr. Morford's case.
Stapleton, pre-trial. We've been looking for a report. I don't know if we'll ever get one from Shawnee. Hard to get reports from them.
I don't have one, Judge.
How's the state going to proceed?
Well, Your Honor, we have had contact with the alleged victim in this matter. He says that there's been no further problems, so that's good news. We would like to have something from Shawnee. We didn't have anything last time either. No, I take that back. I have a note here that says Shawnee says he's compliant. I don't know how we got that, but maybe there was somebody here.
I don't know. There's no written report in the file.
So we'd like to see that he's been compliant. I realize it's not always easy to get something in writing from them, but if we set it out another month or so, maybe if you bugged them for a month, maybe they would finally get tired of listening to his requests and do a report.
But Judge, we're upon with that. I will do what I can to try to get a report from Shawnee.
20th of November?
Yes, sir.
November 20th will be the next hearing, 10 o'clock.
State of Ohio versus Kevin Browning, case number TRC 23690, A and B.
Smith's case set for pretrial.
It is, Judge. The state is furnishing with the name of a potential witness in this matter. I got that this morning. Obviously, I've not had a chance to look into it. If we could come back, perhaps in a couple weeks, give me a chance to follow up on this additional witness. And I've got some dates here, Judge. One thing I have left in October is the 27th, or the 3rd, 10th, 27th of November.
What were the November dates?
November 3rd, November 10th, well, that's, yeah.
That's a holiday.
That's a holiday.
9th is doable.
I'm in Judge Walter's court that day. I'm here the 27th of November, the 3rd of November, or the 27th of October.
Well, none of those work, so give me some more dates.
Okay. Come up here. Yeah, the problem is I've got a rape trial and a murder trial coming up, so my schedule's getting a little thin. I could do,
How about the 13th of November?
that starts the murder trial and common pleas. It's blocked off for 5 days. I don't think it's going to take 5. I could do the 17th of November.
That's a jury trial here.
Is that, oh, okay.
20th.
20th, I've got something at 9. If I get here at 10, 10:30, that'd be fine.
We'll be here well past.
I can be here the 20th, yes, sir.
November 20th will be the next hearing for pretrial, 10 o'clock.
And, Your Honor, just so the court's aware, there was an indication of someone who called in a report about a driver, and all they had was the first name, but they also had a phone number. And I did some investigative work myself and found a first name and last name, and sure enough, it is the individual who witnessed something.
Okay.
And we talked to her this morning, and she can be a witness for us. So
I just need a chance to
our
talk
case
to her.
was kind of a little bit more tenuous before we located this individual.
Yeah, I was prepared to move to dismiss if they didn't have this lady, but I will follow up with that.
All right. Good work, Mr.
He did
I
what the
think
highway
I should
patrol
have been
didn't
an
do.
investigator instead of a...
State of Ohio versus Jamie M. Saber, case number TRD 231077.
It's Mr. Smith's case set for pretrial.
Yes, Judge, there is some potential evidentiary issues in this case. I'm not really in a posture to file a motion at this point. I know that the insurance has been contacted. I think that's being taken care of. This is our second pretrial. I would like to also set this for another date if I might. We'll waive time to follow up on these potential evidentiary
When did
issues.
you want to set it?
We can set it the 20th, that same day. That's fine.
Okay, defendant's request, case is continued to November 20th for another pretrial. 10 a.m.
Thank you, Judge.
State of Ohio versus Allison L. Chapman, case number CRB 23535. Did not check in, Your Honor.
It's Attorney Tyler Smith's case, pretrial.
Yeah, Your Honor, I don't have any idea where she is today. I know that discovery was answered on this one, but we're trying to locate. The video was produced by the state and was left on the conference table, but we both looked, we can't find it, so she's going to burn a new copy for me. So I'd say we just set a new pretrial date, and I'll try to get her in the next 7 days if I can find her.
State's position.
We're not opposed to a continuance, as long as there's a time.
We'd waive time.
Okay. How about the 30th of October?
That's fine.
2 weeks, October 30th for pretrial, 10 o'clock.
All right, thank you.
You're welcome.
Here you go.
State of Ohio versus Clifton Mills Jr., case number CRB 23555.
All right, Mr. Mills, have you hired an attorney?
I have.
And who was that?
He's here. Mr. Crenshaw?
Who is it?
Oh, Means?
Yes.
All right, Brian Means, in the courtroom.
Does Amber Mills have a new case here today?
Yes. Right here.
Is he the victim of it?
Yes.
Your Honor, Mr. Mills is alleged to be, have committed an act of domestic violence against Amber Mills.
And I don't see her here today.
Well, she's in the jail. She's got so many charges we can't even keep track of them. She's in fact got a new one for arraignment today, violation of protection order, which I assume is against Mr. Mills.
Yes, sir.
She's got 2 felony charges of assault on a police officer in Ironton. She's got other charges pending here of violating the protection order and domestic violence. And I believe that well, that's the one in which Mr. Mills, it's a cross filing. At this point in time, I believe it's appropriate. This is a father and daughter situation.
I'm familiar with it.
And Ms. Mills is somewhat, in our estimation, out of control.
I represent Ms. Mills.
And so,
Mr. Thompson.
I think we'll go ahead and nollie this case against Mr. Mills.
All right, Mr. Mills' case is nollied, and I'll see
What does that
Amber Mills when we get to the jail by teleconference.
Thank you, Your Honor.
Your case is dismissed, sir.
All right, thank you, sir. Can I ask you a question?
Yes, sir. Probably should ask your lawyer first. Right here, he's on the other side.
Sorry about that. Thank you, Your Honor.
You're up.
State of Ohio versus John A. Sloan, case number CRA 23600. John Sloan. Not check in, Your Honor.
John Sloan is set for pretrial. He did not have a lawyer. Oh, this is on a extradition matter. Is he still in the jail?
He is not in jail.
Okay. West Virginia was able to pick him up before today, and apparently they have done so because he's not in the jail. Consider is dismissed.
State of Ohio versus Jerry L. Cheney Jr., case number CRB 23493. This is Mr. Steyer's case.
Mr. Steyer is here. At 11:30.
You can't see what it is because it's so it's the scene before the people have guys trying to do. What's what people well, he's got to plead guilty. And I mean,
This is case number 23493. Well.
Okay. I don't have a copy of the video at this point.
Mr. Steyer, I left, did you get the letter?
I did, Your Honor.
He may need that down the road.
I did, I added that to my file, thank you.
You're welcome.
I think you should watch the video. I've got it from your office, so it's available.
Okay.
You better have it.
Your Honor, there was apparently this incident occurred at Walmart, and originally the sheriff's office got a copy that didn't have anything on it, and then after that, I guess they've gotten a copy that you can actually see something. I haven't seen it yet. Mr. Steyer has. And so I'll get a hold of the copy and I'll watch it, but we believe that we have evidence that this actually occurred and it was a very serious situation. So we're okay with a short continuance And we'll come back after having watched the video and be able to.
Right, this is a situation where the video, I think, goes more, I mean, the video as it exists, I got it from the prosecutor's office. Initially, they thought I think it didn't work, but I think Mr. Lehman got it, figured out how to get it copied correctly. It's surveillance video down from, looks like it must be either up on the roof of the building or up on one of those high poles. It's down into the parking lot, and you can't actually
It's outside the building.
It's outside the building. This took place in the parking lot. And you can't actually see who anybody is from it. It's just, you can see what look like kind of the vague forms of human beings walking around and interacting with each other. But I think that it still shows a little bit, of information that would be useful to Mr. Heald in determining how to dispose of this matter. So I think it would be worth our while to continue it briefly so that he can watch the video.
All right, and there is an error in the complaint. I don't know if this was, I don't think it was addressed previously. In the complaint, in the last paragraph, it has a different defendant's name. It has Kaylee Sturgeon. I assume it's a cut and paste issue, but it needs to be amended.
So
We have no objection to that,
We'll
Your
make
Honor.
that amendment, Your Honor.
All right, I'll show the amendment to read Jerry L. Cheney Jr.
And we would just ask for a date convenient to the court.
Well, the dates, well, actually, the 30th is not bad, but after that, it's into November. October 30th is okay?
Do you think you could watch it by the 30th?
Yes.
Okay, the 30th is fine with us, Your Honor.
10:30 for another pretrial, 10 o'clock.
10 o'clock.
State of Ohio versus Andrew Curry, case number CRA 23464 A, B, and C, CRB 23463, CRB 23291, CRB 2361, CRB 22350.
I'm going to try to get him to look with that.
All right, Andrew Curry is here. He's at Bethesda. Mr. Steyer is representing him.
We have looks like a pretty positive report from Bethesda this week. And then I have some photographs that Mr. Curry has provided. I'm going to show to Mr. Heald. This is a before shot. This is an after shot.
It's progress.
Well, and you can see me hauling away a bunch of the garbage. Now, my understanding is the co-defendant's case has been reduced at this point. There's a co-defendant on this. That's not set today. My understanding is her case has been reduced to a misdemeanor at this point. This is charged as an open dumping. What's her name?
Tony Walters.
Walters?
Yeah, Tony Walters.
Tanya Walters. Tony Walters, I'm sorry.
She's not on the docket today.
No, I think her case has already been disposed of.
Okay.
I don't know if the state's ready to, have you had Mr., I can't think of Seth's last name. Have you had Seth go over there and take a look?
Yeah.
How recently?
Well, this morning.
Okay.
And he says that there's still a bunch in the back of the property that's not cleaned up. So I guess that's what you're seeing, we're seeing in that picture.
That's my yard sale stuff.
Well, he says that's not garbage. He says
That's my yard sale
just-
stuff on the tarp back there covered up. It's in the yard sale. That's what I do for money.
It's property.
I might throw it away too if you want me to. I mean, I hate to. It's a lot of money.
It's got to be kept in the right way too, and not just piled in the back.
No, not piled up as tarp. It's the tarp
So-
over protecting it.
Your Honor, we have 1, 2, 3, 4, about 5 or 6 cases, and I honestly, I believe they're all still pending.
I think so.
A number of them are at any rate.
Well, there was a theft from 23, earlier 23 that's already put out, and a theft from 22 that was put out.
Right.
We You look good, Mr. Curry.
Thank you, sir. I feel good too.
Good.
I'm gonna be
You
working
look
on
good
my.
except for that cowboy sweatshirt.
I knew you was gonna
Sorry
say it.
about
I
that.
knew you was gonna say it this morning too. You must be a Pittsburgh fan. But anyway, I'll talk to the probation.
Bengals. I'm a Bengals.
Cincinnati, well, whatever. I talked about they're gonna start my community service on the 90 hours I owe y'all on Thursday, so I'll be up there doing my community service on that too. I will.
Okay. You've made a lot of progress. I want
Thank you very much,
to
sir.
say that to you from when you first
I knew
came
you
in
would say
court.
that.
Well, Your Honor,
I'm just giving you a hard time. It's fine.
I know.
You can wear a cowboy shirt if you
I
want
know.
to.
if,
I don't know what they did. I know they got beat week before last. I don't know what happened to them this past weekend.
I know, right? San Fran.
Your Honor, eventually, we're going to need to resolve all these things. We don't want to discourage Mr. Curry from continuing to make progress. I think that the issue of what's left there on the property on this open dumping charge needs to be discussed with Mr. Summers, the enforcement officer, to determine what's going to need to happen with that stuff. Even if it's useful to Mr. Curry now, if it's not moved pretty soon, then it's going to become junk like anything else.
I understand.
We want him to continue with his recovery. He's got a possession charge, I guess, too, and also when he was arrested, there was a resisting arrest. So that's a serious matter too. And an obstructing official business charge. So we're going to want to resolve all those with a plea or a trial at some point. It doesn't have to be today. We want to keep the felony open dumping charge pending until we get a true resolution of what's the status of the stuff there.
well, that in mind, then, Your Honor, I'd like to just set everything out for another date that's convenient to the court. You were saying the 30th is the only date in the immediate future that's available. That's fine if they think that's enough time, but I don't know if it sounds like we might want more time than that anyway.
He's not close to finishing anyway.
No, he's impatient, and we don't care one bit to assist with whatever. We took him out there to help him clean up the yard. So if there's more stuff, we don't care one bit to help him
Okay,
with
let's
that.
give him some more time to get that straightened out.
Okay.
And the more time in recovery, the better. As I said before, you look 100% better than you did when you first came in.
I feel a lot better. I turn my life
Your
over to
demeanor is a
God.
lot better.
I turn my life over to God, that's why.
I'm available most of the court dates in November. I'm not available the 9th, which I think is our substitute date because of veterans that have a trial that day, and I have a trial.
13th of November.
I'm available, I'm actually on the docket already.
All right, November 13th. Don't get discouraged, Mr. Curry. You're doing good. Keep it up, and that's going to be the best possible outcome for everything that you're facing right now.
I understand that, sir.
And if I may, Your Honor, Mr. Curry asked me to raise the issue of his ankle monitor. It is causing him some pain and cutting on him. I guess the one they have on him is a little larger than usual, so it's causing some physical discomfort. Didn't know where you felt on that.
I promise you, sir. I'm good. I'm good where I'm at. They'll take care of me.
I'll do my best. I can't never guarantee ankle monitors.
I've been burned on those before. Even I've had people doing really, really good, and as soon as I take the ankle monitor off, they run.
I understand that.
But at some point,
We have to try.
it has to become you.
I know that. I know
I think
that.
at first you were doing this to stay out of jail because I made you do it. But this is for you.
I know it is for
you, your
me.
family, your fiance, your life. You have to adopt it as you, Sue. I can't cover over you for the rest of your life. So this is part of the process. You got to be able to do it on your own.
I know that.
So we'll take the ankle monitor off and trust you're not going to run.
I promise you, sir.
Mr. Major might see Josh and he'll get arrangements, Mr. Cooper, to get that taken off, and we'll see you on the 13th.
All right, thank you, sir.
Thank you, Your Honor.
You're welcome.
Your Honor, I have to point out that both Ohio teams won yesterday.
No, I can tell you that.
Okay.
You want that, please?
No, I got it. Go ahead.
You sure?
Yeah.
Don't look at it.
I got it. I got it. I got it.
Thank you.
State of Ohio versus Vilma L. Gurgley, case number TRC 23-1297, ABC and D.
Mr. Steyer's case set for pretrial.
Give just a moment to speak to Mr. Hill.
Hey, we'll keep this too.
Yeah, I'll sign that, thanks, sir. That's Medicaid. That's Medicaid. What we need to do is get you something here. Is there anyone here today who accepts Kentucky Medicaid? Well, we don't, she doesn't have Medicaid yet. We think she qualifies, but she doesn't have it. If she talks to you guys, can you work with her to get onto a stream of Medicaid that you could accept? Okay. I think this is one where we might want to look at some treatment. That may be something we could look at that might work to mitigate the situation, but we'd like to have that in place prior to going forward. So what I'd like to ask is for a brief continuance, allow her to speak to Brianne about maybe getting onto a medical card, and then if what she ends up with isn't something, I guess like some of it you can take and some you can't. If it turns out to be something.
You're also from Mark, so.
Oh, is this with Mark here?
I don't know if he's still here.
Oh, that's fine. When I asked, I was the only response I got. So I was gonna say that if that didn't work, we could refer to ARC as a possibility.
When do you want to come back?
Course convenience, Your Honor. And we'll waive time.
13th.
That'd be fine, Your Honor.
November 13th.
10 o'clock. Don't leave till I talk to you.
Here he is. Jeremy just came in and worked.
Oh, okay, Jeremy. This is going on there. We have our copy. I'll come out and talk to you. Just wait for me to lobby. Thank you, Your Honor.
You're welcome.
State of Ohio versus Buddy L. Hardy, case number TRC 23532, A, B, C, and D, CRB 23287, CRB 22600, TRC 1870, and CRA 1864.
Yes, I know. But you have called it.
No, I never want to do it.
This is what they call punk route. That was on the road. Okay. So that is that. So that's
Plus he's got this other truck that's serious too. Yeah. I think I can do that.
I have 18 days on the clock. Do that. Your Honor, we've got two matters here. I'm sorry. Well, we'll talk about it. We'll make it after that. No, I understand that. Okay, Your Honor, we've got two different matters here that are currently pending with Mr. Hardy. One is an alleged criminal damaging. One is charged as a second offense OVI with a refusal. But I've discussed it with Mr. Hill, and I think we're in agreement that the refusal is probably not legally provable here. This is a situation where there was an accident. The police came upon the scene of the accident, and then later, after they had arrived, Mr. Hardy sort of walked onto the scene, came out that he perhaps was the driver. But even if he were the driver and there were an OVI there, I don't think that the state is going to be able to prove that operation of the vehicle took place within the time frame required to enhance the penalty with a refusal. So what we've discussed is that The state's agreeable that in exchange for a guilty plea to the OVI without a refusal and the criminal damaging, the state would be agreeable to, I don't know what the top end of the charge would be, but basically that he would spend the mandatory minimum 5 days in jail and 18 days of home confinement, because I think this is a situation where we can truthfully say that the jail is overcrowded. The only complicating factor, I don't think this is really a whole lot of complication, is that Mr. Hardy has a pretty bad injury to his foot. He is scheduled for surgery on his foot on the 19th of this month. We would like to ask that the jail time be scheduled after he's had time to recover from the surgery. We don't want him to go in with the injury, and we don't want him to go in while he's basically dealing with a wound from with a surgical wound. I think those would both be to his detriment. But he could probably do but we could do that after. I don't know if we'd have a time at this point for that, or if we want to schedule to come back after we get a release from surgery.
Well, what I would prefer to do is just delay the sentencing until he has recovered from the surgery and come back, and then we can finalize it.
And then we also have for him, I have a report from a new behavioral health where he's receiving services. This is in the form of an email. It really doesn't tell us much, basically because he's gotten started with receiving services, and there's not much to report at this time. So, but we can provide that to the court to sort of show that he's established.
Okay. And he will continue this while he's in his convalescence from the surgery?
I think that shouldn't be a problem.
Okay.
So, Your Honor, in that case, then we would enter the guilty pleas at this time, ask to have sentencing set out at a date convenient to the court. If we're doing the 13th, I think that should be, that's close to a month after the surgery. We should at least at that time have a pretty good idea where his recovery is, surgical recovery.
I'll keep you all posted.
I was thinking the 20th. Are you available?
The 20th? That's fine, Your Honor. I didn't want to push it out further than you wanted to. I'm here the 20th as well.
All right, I'll set sentencing in 23-532 for November 20th. There's also 23-287.
And Your Honor,
That's just the possession of marijuana, so he's pleading to that also?
Yes.
That's a companion case.
and then we have this criminal damaging charge.
That's got a separate case number. I'm looking here and see if I can find that
We
case number.
anticipated, Your Honor, that these would run concurrently. We would want a 60-day suspended sentence. He would actually serve 5 days in jail, 18 electronic monitoring, and then the rest of that 60 would be suspended. There's $50 restitution in the criminal damaging charge, so we're going to ask for that too.
And we'd stipulate to $50.
All right, I'm not going to finalize anything until we get him back, so I'm going to set everything for sentencing and pre-trials and whatever's not resolved for November 20th. November 20th, good luck with your surgery.
Yes, sir. Thank you. Yeah, good luck with that, for sure.
Okay, start preliminary hearings.
State of Ohio versus Jennifer Cooper, case number CRB 23506, CRA 23507.
Yeah, I'm pretty sure on it.
Yes. She already pled guilty to the misdemeanor. She has a felony still pending, and she's in treatment.
I'm on 45 days, and there's 90. She's about halfway through. Sorry,
When is it that you believe she might be discharged?
She's about halfway through her program.
45 days.
Yeah.
Another 6 weeks. Okay, it's a good report. Good job.
Thank you.
Come back in 6 weeks, approximately.
Monday, please.
Okay. 27th of November.
Yeah.
November 27th. Good job. That's good for keeping it up.
Thank you.
State of Ohio versus Samuel L. Losey Jr., case number CRA 23602.
It's Mr. Morford's case, preliminary hearing.
He put up a bond. So he put up a bond, Samuel Losey, felonious assault. So if you probably want to waive to the grand jury. No. It's easier just to not waive or have him waive. Your Honor, does court's file have an indication of when he posted the bond?
Yes, it was October the 10th. It's a $10,000 security bond.
So that you don't lose your Judge, we're going to ask you to waive preliminary hearing. Mr. Hill has indicated he would not waive it, we didn't, so we'd like to preserve the bond.
All right, Mr. Losey, so what that means is you have a right to a probable cause hearing here today. You're waiving that, which means your case is going to go on to the grand jury. You're doing that because the state is just going to dismiss it. They don't have to do the preliminary hearing. They can just take it directly to the grand jury. You've got to bond up. You don't want to lose that by not reporting to the common police court when you're asked to. The problem is knowing when you're asked to report, because sometimes they don't do the best job of communicating that an indictment's been returned. So it's up to you, really, in your interest, to keep track of that. And you can talk to Mr. Morford about how to best do that, but you can look at the clerk's website to check to see if you've been indicted, and then you need to get down there to the common police court so that you don't lose your bond. Because if they send a notice and you don't show up, then they're going to issue another warrant. It means you have to post another bond. You don't want to do that. You want to keep your bond that you've already got out.
Yes, sir.
So you might talk to Mr. Morford about that, because he probably won't be the, well, were you hired on this or appointed?
Appointed, hired.
Well, if you get an appointed counsel, it's probably not going to be Mr. Morford, or there's a good chance it won't be. It may be somebody else, and they may not know how to get hold of you, so.
I would like to keep Mr. Warford.
Well, it's not going to be up to me. It's going to be a different judge making the appointment. So if I was the judge, I would keep him on the case, but I'm not going to be the judge. It's going to be down at the common police court in the main courthouse. So your case is going down there. It's not staying here. Okay. I know it's kind of confusing. It's not a system that I drew up, and believe me, if I was designing a system, I wouldn't design it this way. Some of it's historical stuff. You know, we do it that way because that's the way we've always done it. And sometimes that's not always the best way to do things. But anyway, that's what's going to happen. You're going to go to the grand jury, get an indictment, then you're going to be in front of one of the two common pleas judges. And it behooves you to get in there when they want you there, so you keep your bond. That's what I'm trying to tell you. And sometimes you may not know you got indicted, so you need to keep looking to find out if you got indicted. So, all right, you understand, or?
Yes, Your Honor, I understand.
Okay. You need to sign the waiver.
James Markin.
May I approach you on that?
Yes. So your case is bound over to the grand jury, which means it could be presented, it could be 2 or 3 months from now before it gets presented to the grand jury. So you need to keep watching, even though it may be a period of time you think, well, they must have forgot about me. They're not going to do anything. They can be slow sometimes.
Thank you, Honor.
We'll be in touch. Okay, I'll talk to you.
State of Ohio versus Travis L. Salyers. It's number CRA 22-791, CRA 22-418, CRB 22-420.
Mr. Morford's case, preliminary hearing.
May I approach, Your Honor?
Yes. Okay, you're getting toward the end.
Yeah,
You're going to get to go back to work, right?
Yep.
That's what you've been wanting.
yeah, I'm working right now.
So, you've done well. I know it's been, you weren't happy at first about some things, but it seems like you're accepting it now, and I want to congratulate you on the progress that you've made, and the end is in sight.
I appreciate it.
At least the end of this phase, but there, you know, there's going to be additional challenges in that. You know, I spoke to that one gentleman, which I hope you have done this. You got to make this your project. This is for you. It's not about me overseeing you, because I'm only going to oversee you so long. And we're getting to that point where you're going to be moving on to another phase where you're going to be more, you have to self-govern yourself. You know, in other words, I have to do this for Travis.
Yeah.
Not because I don't want to go to jail, not because of Judge Capper, but for me and my family, and I know you got family that depends on it, right?
Yeah, 5 little ones.
Yeah, so you got a long time to go with them, and I remember we talked about that. You want to be a good example for them, right?
Yes, for sure.
Okay.
I'm 10 months, almost 11 months sober. And
okay, that's a
best
great
I've
start,
done in a long
but
time.
it's just a start.
Oh, yeah.
Because I want you, 50 years from now, I want you to say, I got 50 years and 10 months sober now. So,
yeah.
I want you to go long-term sober. As an old man, be sober.
Yeah.
And that's what your kids are going to want too. Right?
Yeah.
When you're an old man, they're going to say, Dad was a good person, was sober and clean, rather than Dad was a drunk and died early because he couldn't stay away from substances. Because that's what's going to happen for the most part for people that have used substances. You're not going to live to be an old man.
Yeah, I definitely.
You're going to die early.
I definitely don't want to go back to that life.
I mean, a lot of people look in the obituaries. A lot of people are dying really early. Fentanyl has taken out a lot of people.
Yeah.
If you're out there using stuff out of the community, off the street, you're probably getting fentanyl and you don't even know it.
Oh yeah, it's in everything now.
So, you just can't use the stuff off the street. Don't use it.
Yeah. I plan to stay in outpatient, and even whenever I do graduate, I'm going to stay with them in outpatient for a while.
I think that's a good plan. Okay. November 27th. Hopefully by then you'll have a job. You'll be back to work.
Yeah, I'm hoping so.
November 27th is your next hearing.
Thank you, Your Honor.
Thank you, Judge. Good work. Keep it up. Okay, we're going to go to the jail and do some hearings by teleconference now.
Butch.
State of Ohio versus Christopher Todd Call, Lawrence County Jail, case number CRB 23626, and Cheryl Carrico's on deck.
Sir, are you Christopher Todd Call? Okay, your audio is off. Can you hear me?
Yes, sir.
Okay, now it's on. I can hear you. I'm Judge Capper at the Lawrence County Municipal Court, and this is your arraignment hearing. You've got a charge in case number 23626 that's a violation of a protection order or consent agreement. The charge alleges that on October the 13th in Rome Township, you recklessly violated a protection order or consent agreement. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
You have a right to remain silent. You don't have to say anything. If you choose to make statements, they can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. Do you understand those rights?
Yes, sir.
How do you wish to plead to this charge filed against you? You can plead guilty, not guilty, or no contest, and not guilty is always the safest plea to enter. It preserves all the rights you have.
Yes, sir. Not guilty.
Do you want to be considered for a court-appointed lawyer?
I don't know if my lawyer contacted me right now. I have a lawyer.
Who's your lawyer? He hasn't has he contacted you, Mr. Hill?
He called me early this morning and tried to explain the situation to me, and it was so complicated, and I was trying to get ready to come to court. I couldn't catch everything. I didn't expect Mr. Call to actually be in jail. I know some things, one of which is that Mr. Call has a case in common pleas court in which it was assumed that he was going to be placed on intervention in lieu of conviction on this coming Wednesday. This case arose just the other day, I guess the 13th, but he and his spouse are in a divorce, and I've been told that this case here has something to do with the children. Is that right or not? Yeah. Oh, he is? Okay, okay. So he's apparently pleading on a bill of information with a victim who's the same victim as the person who had the protection order. On Wednesday.
Is that going to change that?
I don't know. I've texted, I don't know whether Mr. Holt told me that he was coming here today, but he had a case, I believe, in Gallipolis, and he had to cover. And so what I'd like to do, if we may, is recall this.
Okay. All right, Mr. Call, apparently Mr. Holt has talked to the prosecutor. I have not communicated with him. I believe I tried to get a hold of him and look at some other issues because I think he had another case in common police court. So we'll try to get a hold of Mr. Holt. Apparently he had a hearing in Gallipolis this morning, but it may be appearing here later. So we'll have him back after we have done some further research and talk to Mr. Holt. You'll be recalled later in the document.
State of Ohio versus Cheryl Carrico, case number TRD 182577A and B, CRB 15170A and B, CRB 13114. Tracy DeMint is on that.
All right, ma'am, are you Cheryl Carrico? Ms. Carrico, I'm Judge Capper. It looks like you were brought in on a warrant for failure to appear for a review hearing, and that review hearing was September the 8th of this year. It was on you've got 182577, which was a driving under suspension. 15170 was a theft offense. 13114 was a theft offense. So, do you admit or deny you failed to appear for your review hearing back in September? Do you have an explanation for not appearing? I can't hear you. It's very low volume. Can you move your microphone closer to your mouth? There you go. Now I can hear you better.
Okay. I don't have an excuse. I just couldn't get there.
Where do you live, ma'am?
In Iron, behind the local office.
Okay. Well, this has happened before. You were supposed to be going to Riverside for treatment too. Did you ever do that?
Yes, I was there for 2 years now.
Did you finish it or what happened?
Yes, I completed the program.
Well, we've got somebody from Riverside here, so I'm going to let them go get me a history on you, and then I'll have you come back. Cheryl A., middle initial A, right? Carrico?
Yes, sir.
Date of birth, 87?
Yes, sir.
I'll check into it.
Okay, we'll have you back after I get a report up from Riverside. We'll decide how we're going to proceed. So I'll recall you later.
Your Honor, I had called Tracy DeMint, and we got a message that he is currently at the hospital.
Okay.
So they're not sure when he'll be back.
All right, Tracy DeMint was transported from Lawrence County Jail to the hospital. I think he has not been arraigned. So I'll continue this till Friday for arraignment.
Your Honor, he also has a complete probation violation.
Okay, so he should be going, I don't know if he'll go back to the jail, but he should be in jail. So I'll set it for the 20th for arraignment.
State of Ohio versus Corey Little, case number CRA 23617, CRA 23605, A and B, CRD 22491, CRA 22405, CRB 23194. Brandon Masters is on deck.
That's not Corey Little. That's Josh.
Well, he's way down the list.
Well, that's good. He's in the chair. So
Okay. Okay.
I think this is Mr. Morford's case.
State of Ohio versus Joshua Carter, case number CRA 23599.
Yes. This is the one I believe you texted me about
It
Friday,
is.
Judge.
He was released to Shawnee with an ankle monitor. I don't think they want you.
I don't think so either.
You're lucky you didn't get charges filed against you inside the county. So I think this, from what allegedly occurred there, and this was a breaking and entering anyway, I think. So this just needs to go to the grand jury.
Okay. Is this on the docket today? Because I don't...
No. What happened was he was released to Shawnee with an ankle monitor on October the 10th. There was all kinds of problems. They contacted me. I actually told them to contact the police there to file charges. They did that, but the police didn't want to file charges, I guess, because there were charges here. They brought him back to court and ordered him into custody.
When was that set on the docket?
It was set for October 27th.
Could we get a file and
Yes,
recall it, please?
All right. We're not making much progress at the jail, so we'll have you back, Mr. Carter, after the prosecutor gets their file.
Thank you, Judge.
State of Ohio versus Corey Little.
Now we got Corey Little.
Brandon Masters is on deck.
Corey Little was Mr. Steyer's case. Is this Corey Little? No. We need Corey Little. Who is it?
Timothy Henry.
We'll do Timothy Henry.
State of Ohio versus Timothy Henry, case number CRA 23614.
Okay, this is arraignment on Rule 4. No, actually, we did the arraignment last week. All right, you wanted some time to see if you could post bond, Mr. Henry?
Yeah.
And you're not able to?
No.
Okay. So what I'm going to do, I'm going to order, and the sheriff's office should go ahead, order Ross County to come, or let them know that he's available for pickup, and I will give them a week, so that's going to be the 23rd. I'm going to put him on my docket for 10 o'clock on the 23rd, but let Ross County is supposed to pick him up before 8 a.m. on the 23rd. So if you're still in the jail on the 23rd at 10 a.m., I'll see you. If not, you'll be in Ross County by then. So Ross County should be notified he's available for pickup.
Now it's time for Corey Little, Your Honor.
Okay. Corey Little is Mr. Steyer's case. This is 23-617, preliminary hearing, 23-605, 23-218, 22-491, and so on, and so forth.
Your Honor, I believe we'll be taking testimony on at least one of these. The intention was probably to take testimony on both of the currently pending preliminaries, but I'm led to understand that Mr. Major's not here, who was going to be the witness in one of them. So I'm not sure if the state wants to make a motion on that basis and then deal with the cases at another date, or what?
I think he said he was going to be back. Do we have any further information? Let's just, we'll put it off and recall.
Recall this later in the docket.
Okay.
Thank you.
All right, Mr. Little, we'll recall you later in the docket.
State of Ohio versus Brandon Masters, case number CRB 23441. Amber Mills is on deck.
Brandon Masters.
Yes, sir.
All right, Mr. Masters, I'm Judge Capper. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. If you choose to make statements, it's all on the record and can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove the charge beyond a reasonable doubt. Do you understand those things?
Yes, sir.
You're charged with a theft offense from Walmart on July 12th of 2023 in Fayette Township here in Lawrence County. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir. Your Honor, I was currently in a rehab facility over in Scioto County, and I've been calling here trying to get this situated, but they said they didn't have nothing on me here. And I don't know, but now it's popped up. I don't know, I was just trying to, I've been clean for a little bit. I was just trying to see if maybe we could just knock this to where I was at in the rehab facility.
Okay, Mr. Hill, do you want to just knock this to where he was in the rehab facility?
Well,
It's not up to me, I'm not the prosecutor, so they file the charges and prosecute cases, so.
I'm sorry, Your Honor, I was looking through other files.
He's got a theft from Walmart, and it's back in the summer, he says he was in it. What rehab facility have you been in, sir?
I've been in Scioto Behavioral Health in Scioto County.
How'd they find out, how'd you get arrested?
My parole wanted me to take care of all this, so they arrested me to get it all taken care of.
Okay.
Your Honor, if I may, Mr. Masters has an ADA.
Okay, yeah, he's got a parole holder too, so.
And did he enter a guilty plea or not?
He has not, he wanted you to knock this to a rehab.
Knock it to a rehab?
Yes.
Well, I think it was a disposition, we would definitely agree to have him go to treatment as a disposition in this case.
Okay, I take that, what they mean, Mr. Masters, is if you plead guilty, they'll recommend that you go to rehab. That's what the state wants.
All right.
Do you want to plead guilty?
Yeah.
That means you're admitting the charge is true.
Right.
All right, I'll accept your guilty plea. Is there anything else you want to tell me about this? Okay. Okay, we're back to Brandon Masters, 23-421. 23-421.
Doesn't it just seem like it's so crazy? It's just got so much crazy. I don't have that file.
All right, Mr. Masters, I'll impose. Let me look at what the affidavit says. Doesn't tell me how much. I'll impose a $50 fine, order you to pay court costs, 30 days in jail. I'll suspend all 30 days on the condition that you complete treatment.
Where is that file?
And where did you say you were going to treatment?
I was at Scioto Behavioral Health.
Okay, at Scioto Behavioral Health. Do 30 hours community service. 2 years of level 4 probation. Stay out of Walmarts. Review hearing is going to be April the 15th of 24. At 9 a.m.
Okay.
So you got to do what you're ordered to do by April the 15th or show up for a hearing and explain why you didn't get it done at 9 a.m. on April 15th. That gives you a long time to get everything finished.
Okay, and so you guys will contact APA, let them know?
No, the jail will do that. So your warrant from this court is going to be dropped, though. We'll drop the warrant. So that'll let them know that they can do whatever they want to do with you. You'll still have to deal with parole authority.
I thought you said you was gonna recommend it to let the APA know that what you guys did.
We're going to drop the warrant. I mean, it's up to them what they do. I'm not going to tell them what to do. Yeah, that's all.
State of Ohio versus Amber Mills, case number CRB 23-621, CRB 23-603, CRB 23-556, and Mary Rubel is on deck.
All right, Amber Mills has new charges and old charges. Mr. Thompson's her lawyer, he's here. She's got a new charge in case number 23-621, violation of protection. Do you waive a reading of the charge?
Yes, sir.
I'll appoint you to represent her in a not guilty plea.
My understanding is that there are felony charges in the common pleas court.
Ironton Municipal, and I don't know whether they've gone over to common pleas yet or not. 2 felony assaults on police officers.
Okay. What do you want to recommend here on this new charge?
$10,000 cash or surety bond, Your Honor. She's got charges pending already in this court, and then she gets new ones.
All right.
Request to go to Bethesda.
Yeah, but
Release the judgment.
you'll have to get everybody on board, because you've got charges in Judge Waldo's court too, so.
They didn't have the paperwork on the one charge, right now I'm getting, something else that I have to go today, and I don't know what that is either.
You should be going to Ironton Municipal this afternoon, right?
Yeah.
I'll go down there this afternoon after work.
Okay, do you want to put her back on the docket for when? A week?
Yeah, 1 week, please.
Is Taylor there?
She is.
Will she be at Ironton today?
She says she will.
Can we think about an OR bond subject to being picked up only by Bethesda?
We're not in agreement with that.
Okay. Well,
If I was over without me, I still have to pay this.
still have a bond to post. If you can get Judge Waldo and everybody else on board, then maybe you can ask me to change it before next week. But as of now, I'm setting it for the 23rd, October 23rd.
So if they say I can be released to them today, and they ask you to change it, can I get be released to Bethesda?
I'll be in Ironton on Thursday, we'll see what's going on.
Perhaps. I'm not saying absolutely. The prosecutor is saying no. I'm not saying no.
It's today.
I understand that.
Okay, I just heard Thursday, so I didn't know. I wasn't aware of these charges. When I went to court, they didn't have my paperwork. So I got these.
It should be arraigned today, but it won't be until Thursday that she has to hear. It's my understanding.
Okay, I set your hearings here for next Monday, October 23rd.
What does that mean?
The next hearing is October 23rd here in this court. And as of now, you've got a bond to post. If you can convince Judge Waldo and everybody else concerned that you should go to treatment with an OR bond, then I'm not saying I won't say yes, but I'm going to have to say yes over the objection of the prosecutor. He wants you to stay in jail at this point.
State of Ohio versus Mary Rubel and Emily Smith is on deck.
Okay. That's fine. Yeah, no kidding. Should I do it?
All right, ma'am, are you Mary Cecil Ellen Pater Rubel?
Yes.
I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything, but if you choose to say things, it's all on the record. It can be used against you. You have a right to have an attorney, to have one appointed, to have bail, to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes.
The charge is domestic violence. It alleges that on October the 15th in Rome Township, you knowingly caused or tried to cause physical harm to Claude Pater, and that he's either a member of your family or a member of your household. That's a domestic violence charge. Do you understand that charge?
Joshua.
how do you wish to plead to this charge?
I'm not sure. I haven't talked to anyone.
Well, if you're not sure, you should enter a not guilty plea.
Not guilty.
Do you want to be considered for a court-appointed lawyer?
Yes, please.
Do you have a job?
I'm a caregiver, and it's been sporadic. I worked 8 hours last month.
Okay. I'll appoint Mr. Smith to represent you. Enter a not guilty plea for you. What's the state's position on bond? And is there a protection order request?
We will request a protection order.
Okay, Miss, do you go by Pater or Rubel?
Rubel.
Miss Rubel, I'm ordering that you not go around or contact Claude Pater. Is that a problem?
I have not been doing that at all.
Well,
He came on my property.
that wasn't my question was, is it a problem going forward in the future? If I let you out of jail, I mean,
It is not a problem.
you all don't live together.
It is totally not a problem.
Okay, so you've got another place to stay other than with him.
I live in the house there, yes. That's my house.
Well, does he live there also?
No, he lives next door.
Okay. Well, I don't want there to be another allegation of a problem, so you have to stay away from him.
I will do that. I have been.
Okay. What's the state's position on bond?
As long as there's a protection order and she understands she can't be in contact, then we're okay with an OR bond.
I'm going to let you sign what's called a signature bond. So you're signing something that says, I promise to come to court, or I'll pay $1,000 as a penalty for not coming to court. Do you understand that? And you get a warrant if you don't come to court. So, Mr. Smith, what's a good time frame for you to come back?
Judge, I'm here the 27th of this month, or the 3rd, 10th, 20th, or 27th of November.
Can't do the 30th this month?
That's where I'm going to be in Huntington at 9. If we could do it like 10:30 or 11, I could do it.
Oh, yeah.
Okay.
I'm saying your next hearing in 2 weeks, so that's the 30th.
Yes.
Ma'am, October 30th. You know where the court is in Chesapeake? Ma'am, can you hear me?
Are you asking me?
Yes, ma'am.
Yes.
Mr.
No,
Mr. Smith knows where the court is.
I'm pretty sure.
Okay.
Yeah, do you know where the court, where to come to for your hearing?
I'm sure.
It's across from the flea market on County Road 1, Old 52,
Okay.
in Chesapeake.
Do you have a telephone number when you're not in jail so I can call you? Do you have a cell number?
I do.
What's that number?
This is your lawyer asking.
Hey, I've been there, I'll stand up. Go ahead.
704-608-6570.
It's 704, not 740?
740?
It's 704 right now. Yeah.
608-6570?
Yes.
Okay, I'll be calling you. It won't be a day. I'll give you a call tomorrow, Wednesday. We'll talk about the case before your next hearing.
All right, thank you.
Thank you, Judge.
All right, so you're going to get out as soon as the paperwork gets down to the jail. You got to stay away from Claude.
Won't be a problem.
Okay.
State of Ohio versus Emily A. Smith, case number CRB 23627, and Cheryl Carrico is on deck.
Emily Smith.
She says that's how I hear her.
Need Emily Smith. Okay, let's go ahead and do some of the ones that are here.
Okay.
We got some-
State of Ohio versus Michael Voss, case number CRD 23628.
This is an arraignment here, Michael Voss. Sir, are you Michael Voss?
Yes, Your Honor.
All right. Mr. Voss, you got a domestic violence complaint filed against you. It's a first-degree misdemeanor, maximum penalty is 6 months in jail, $1,000 fine. The complaint alleges on October 14th of 2023, you knowingly caused or tried to cause physical harm to Denise Voss. Maximum penalty, 6 months in jail, $1,000 fine. Do you understand the charge?
Yeah, Your Honor, could I do like some kind of a treatment program or a community service? Because I got an 85-year-old mother I got to take care of.
Well, let's see what the prosecutor.
And I do work.
What plea do you wish to enter, sir?
Well, I'm guilty of the charge, but I'd like to do some kind of a community service or just so I don't have to have any jail time. Because like I said, I got an 85-year-old mother I got to take care of.
If you enter a guilty plea, you're admitting the charge is true and you waive your rights to have a trial and have a lawyer. Is that what you want to do?
Yeah, I guess. I mean, I can't lie to the court. I'm guilty of it.
Well, and one of the things you need to realize, this is the kind of charge that if you have a conviction, if you get another one, it ups the ante. In other words, the penalties increase each time you get one. It could be a felony if you have this on your record. You understand that? The next time you have one.
If I have another domestic violence issue?
Correct.
Well, that'll never happen, though. I'll
Okay.
make sure of that.
Do you want to continue with your guilty plea then?
Well, what would not guilty do for me?
It preserves all of your rights as a defendant, and then you would be eligible to get a lawyer, have one appointed if you can't afford one. You said you're working, I'd have to ask you about your income if you want court-appointed counsel.
Well, then I might as well plead not guilty then.
Do you wish to be considered for a court-appointed lawyer?
Yeah.
What do you do for a living?
I work at a factory, just labor work.
Where?
Willard Mothball Factory.
Are you paid by the hour?
Yes.
How much per hour?
$13.25 an hour.
Okay. How many hours a week do you work?
40.
How many people in your household?
It's just me and my mom.
So you're making about $27,000 a year gross income?
Yeah, possibly, yeah.
Well, I think you're actually more than what I'm supposed to appoint counsel for a single person. Okay, you're right on the edge, so I'm going to go ahead and appoint counsel. I'll appoint Mr. Morford to represent you.
What's the name?
Not guilty plea is entered. Safe position on bond.
Your Honor, Ms. Denise Voss just here and spoke with me. I don't know if she's still in the courtroom or not, but she did not want a protection order.
Okay.
And she would like to see her brother take part in anger management counseling. And if he's willing to do that, then we'd be willing to continue the case. And if he's successful in completing that, we would be agreeable to dismissing the charges later on, considering, whether there's no further problems between the parties.
That's agreeable with Mr. Voss, Your Honor.
How's he paid for medical services?
I want to go to jail.
How do you pay for the medicals, sir? Medical card?
No, out of my own pocket.
Pocket?
Self-pay, okay.
Self-pay, yes, sir.
Well, and he lives where, in South Point? Have you ever had any mental health treatment before?
No.
Well, we could try PATH, is right down here in the plaza in Chesapeake. I'm not sure what their pay scale, if they can take people on a sliding scale.
I can't help, I don't know either, Judge.
But we can continue this for a while to let him try to seek some counseling. Is the sister still here, or did she leave? You want to come up and talk to the prosecutor? Is there any kind of substance use issue here? No? You don't think so? All right, let's try, I'm going to recommend that he check out PATH. Come back in a month, approximately, for another hearing.
There's a pathway.
I think it's called Pathways, I don't know.
PATH.
He was referring to one in South Point, Your Honor,
See, I don't know.
Pathways, I believe.
I think it just delivers people around, that's what I think.
Well, let's
PATH
try
is
the-
right down here in Chesapeake. It's fairly new.
It's in Chesapeake, is it down here?
I'd have to find out where that's at. Is it close
Right
to
here in the middle of
Where City National Bank used to be, or National City Bank was there.
Used to be grocery stores in there, there's a Dollar General in there.
It's across from the Dairy Bell.
Yeah, across the street from the Dairy Bell, that's a good landmark. You know where that is?
I've been here a long time. I'd second this.
Up here to the
It's
first stop.
probably a
to the
mile
left.
if that from here. November 20th will be the next hearing for a pretrial. Not guilty pleas entered. He can sign a $1,000 signature bond.
And I've prepared a time waiver too, Your Honor.
You need to sign that bond for the judge.
Stable versus Melissa Dempsey, case number TRC 21-1044, CRB 21-291. Mr. Thompson, question.
All right, Melissa Dempsey, set for sentencing.
Cheryl Carrico is on deck of today.
So what happens?
Are you Emily Smith, ma'am, that's in the chair? You're Emily Smith, ma'am? Her audio's off. You are Emily Smith? Still off. You're Emily Smith?
Does it work?
It is?
Yes, sir.
Okay, we'll be with you in just a moment. All right, this is Mr. Thompson's case, Melissa Dempsey, set for sentencing.
Josh just looked this up on the computer, and I guess there are judgment entries on both these. I think this is more of a review.
Well, it's been said as a sentencing, I think probably because she missed a hearing and posted a bond, that's what happened. So we put it on as a sentencing, just as a reminder that we're not in review anymore. She has a bond up, so she's been making payments.
Your Honor, she still owes 24 hours of community service. She was running 6 hours.
Okay.
She has a new job, and when are you going to be able to do community service?
I'm actually got off tomorrow, so I'm going to try to call the dog pound, see if I can go there tomorrow. It's just, I'm working at the Holiday Inn Express in Ironton, and we've been working 6 days a week, just short-handed, so. I'm just
And I
doing
think she
one.
paid $40 on the fines today. 35, sorry.
Online or what? 'Cause
Yes, sir.
Okay. November 20th will be your next hearing for sentencing, 10 o'clock. Okay. Emily Smith is 23627. This is for arraignment, and you are Emily Smith.
Yes, sir.
I'm Judge Capper of Lawrence County Municipal Court, where your case is filed. It's a complicity to commit theft, and the charge alleges that on October the 16th of this year, that you helped in the commission of a theft offense. That's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir, I understand the charge.
How do you wish to plead to it?
I don't even remember.
Okay, I'm going to enter a not guilty.
So,
I'm going to enter a not guilty plea for you then. Do you have the money to hire a lawyer?
no, I do not. I don't know. I just woke up in jail, so I don't know how to answer, really.
Well, if you don't know how to answer, you should enter a not guilty plea. And I have entered a not guilty plea for you. Do you still live at 1000 County Road 104, Chesapeake?
That's where my mom lives. I'm currently homeless.
Okay, what's your mom's name?
Amanda Pinkerman.
Can you go back to her house?
Can I?
Yes.
Yes, I probably can. I haven't been able to get a hold of her, but
Where have you been living when you're not in jail?
just wherever I can. Multiple different places.
Okay. Mr. Stratton, I'll appoint you to represent Ms. Smith. Would your mom allow you to come back home?
I'm pretty sure she would allow me to come home, yes.
You know what her phone number is?
Yes, I do.
What is it?
304-521. 7992.
7992.
Yes, sir.
So that's her cell number.
Yes, sir.
Does she work?
Yes.
Where does she work?
I think they changed the name to Lorraine's. It's on Route 60.
Is it a restaurant?
No, it's like gambling, like game machines, like slot sheets. Where
Okay. She says she's been homeless, so I'd like to, before I release her, make sure she's got a place to go to. Do you want to call?
I'll call her.
Mother's Amanda Pinkerman. Did you get that phone number?
Yeah, I got the phone number.
All right, so I'm going to have your lawyer call your mom and talk to her about you coming back there, so you got a place to stay. It's starting to get a little cold at night. You need a warm place to stay. And,
Yes, sir.
we'll have you back after he's done that.
All right, thank you.
State of Ohio
I appreciate you, sir.
versus Cheryl Carrico on a recall. Case numbers TR date 18-2577, CRB 15-170, CRB 13-114.
Cheryl Carrico, we were going to get a report from RRS.
Your Honor, she has been in services with us before, but it hasn't been for years.
Okay. And she didn't complete, doesn't sound like?
I'm not sure, where we've changed billing systems, we don't have access to the old one.
Okay.
Yes, sir. I went there on my own.
Well, it looks like this has happened before. You've missed hearings in the past and got jail time over it. Where have you been living?
I live I'm district behind the local office, so.
You live
I
behind
don't know
what?
the drivers up, behind the local office on this street.
In Ironton?
Yes, sir.
Okay. How'd you get picked up?
My friend was driving and she got pulled over. He wasn't charged with nothing, though.
Do you have kids?
Yes, I do, sir.
Where are they?
With my mother right now.
Well, I think what we need to do, it's going to slow things down, but what the right thing to do is have you do a urine screen. What's that going to show?
I haven't done nothing in weeks.
Okay, well, let's see if it's clear. Once you do a urine screen, then I'll have you back.
State of Ohio, Regional Christopher Todd Hall, Orange County Jail, case number CRB 23626.
Christopher Call is Mr. Holt's case.
Joshua Carter, on deck.
Yeah, if you want.
Hey, look, it's all on back in my head. Yep.
All right, this is This is 23-626. Does he have a case in common pleas also?
Yes, but it's been, you know, this is a very long and complicated issue. The agreement has been reached that he is going to enter a plea on agreement information to F4, disrupting public services, and do ILC. We also just resolved divorce, and there's also a CPO case, which this criminal case here we're here on the for today arises. Mr. Call, there was an ex parte protection order filed that had both his wife, soon-to-be ex-wife, and 2 children on the order. We had a hearing. There was no allegations made in regards to the children. The temporary protection order out of this court did not mention the kids. What's happened is that the magistrate in common police court puts in a clause that any CPOs are subject to the orders of domestic relations cases. Well, he has time with his kids, and it's going to have 50-50 shared parenting. He got arrested going to Chesapeake Elementary School where they go to school. No one called the school resource officer.
Fairland.
Or Fairland, excuse me, I'm sorry. Fairland.
There's a difference.
Yes, there's.
Not the people in Ironton.
You're getting your heart. And he was arrested on Friday afternoon, picking up kids from school. Spent the weekend in jail. It's a paperwork area on there.
Mr. Heel.
Well, we received a copy of the magistrate's order out of the divorce case, and the magistrate in that case ordered that all prior orders issued herein in 23 DV 280, which is the civil protection order case, are subject to this magistrate's order and modified so as to facilitate the defendant's ability to exercise his parenting time with his minor children. So this only involved him going to the school to pick up the minor children. This was ordered on June the 9th. The original protection order was entered in May. So this was in effect. I don't know how that works, whether this entry gets turned over to the sheriff's department to put him. I don't know, except that he, I believe, had a good faith belief that it was okay for him to pick the children up.
And there are no allegations of anything.
I think it was actually his niece and nephew he was picking up according to the affidavit, not his children.
Correct. So
that's what the affidavit said.
It was his niece and nephew.
Well, so anyway, I believe it's, under the circumstances, appropriate to nollie this case.
No objection, Your Honor. Thank you.
All right, that means your case is dismissed, Mr. Call.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Joshua Carter, case number CRA 23599. Corey Little is on deck.
Okay.
All right, Joshua Carter is Mr. Morford's case.
Your Honor, you allowed me to get the file.
Yes, get your file.
So that I can see and remember what happened. On the 10th of October, the court ordered a $10,000 OR plus GPS, plus he would go to treatment. Now, at that time, we never represented to the court or the defendant that we were going to keep the case here.
Correct.
So, I'm not sure what's happened to cause him to get back in jail.
Lots of problems at Shawnee with threatening staff, neighbors, that sort of thing.
It continued outside too, I believe,
Yes,
didn't it, Judge?
police were called.
So, we're going to take the case to the grand jury. Now, we did not anticipate that we would have this hearing today.
Correct.
And we don't have a witness present unless it's by accident. Is that Deputy Adkins out there?
That is low.
We do have a deputy here that was to be, well, he's here on another case, but if we needed to, same, different case altogether. But if he had an opportunity, I mean, if we needed to have a preliminary hearing today, we could do that, although they may just want to waive, I don't know.
How you want to proceed, Mr. Morford?
Judge, I can't waive his preliminary without talking to him. Do you mind recalling it? Let me call down there.
We'll recall.
Speak with him.
All right, Mr. Carter, your lawyer's going to call down and talk to you, and then we'll recall it.
Ask them to put you by the phone, Mr. Carter.
Even by the phone. This makes me hate teleconferencing.
State of Ohio recalls Corey Little at Lawrence County Jail. Case number CRA 23617, CRA 23605 A and B, and others.
Your Honor, I was going to add that, Mr. Major.
Okay. Yeah, well, let's put it off then. We're not ready. We're waiting on the major to call back his availability.
State of Ohio recalls Emily Smith of the Lawrence County Jail. Case number CRB 23627.
Your Honor, I tried to call Ms. Pinkerton, and it just rings and rings and rings. I also tried to text her, and I have gotten no response.
Okay.
So, this is a complicity defense, I believe.
Who is this?
Smith, Emily Smith, to recall.
I got Cody Smith, I got William Smith.
So it's an arraignment. Okay.
Oh, that young lady. Your Honor, we have some concerns about her.
Me too.
She's homeless, she doesn't remember being in the place, she woke up in jail not remembering what happened to her.
Looks like there's very high evidence that she's using drugs from what was found on her.
Our recommendation was going to be a fairly substantial cash or surety bond unless she would agree to be assessed and entered into treatment.
Ms. Smith, is that something you would want to try, treatment?
Yes, I would. I've been trying to get help for a long time and nobody will call for me. I don't know what to do. I need help. I wanted help for a long time.
Do you have an Ohio medical card?
What is it?
Do you have Ohio Medicaid?
I have West Virginia Medicaid. I think I
Okay.
did.
She's in Ohio now.
Yeah. Well, we could do OVP or somebody can switch her over. She's actually, her mom lives in Ohio. I think you're from Ohio originally? Is that right?
I can take her, it's not a problem. We did take West Virginia.
Okay, would you be willing to go to a faith-based inpatient program? You'll have a
An
place.
inpatient program, is that what you said?
Yeah, that means you got a place to, warm bed, food to eat. You're gonna have to, no drugs, and you gotta enter into counseling to get clean.
Your Honor, I think she misunderstood you. She's willing to go inpatient, but I don't think she heard the faith-based part of it.
Yeah, and it's a faith-based program.
What's the difference between the?
Well, that just means that the folks that run this are Christians, and they think that's an important part of the recovery process is your faith.
I mean, I don't see why the faith-based would matter.
Well, it's up to, if you don't, I can't force people to go to a Christian program if they're not Christian or they don't believe in that. I can't force someone to go to that kind of program, but if you're okay with it, you can go there. They're nice people.
I'm okay with it, yes.
Okay. Do you think you need to do an assessment, or have you seen enough?
No. What's her name?
Her name is Emily A. Smith.
I'm good today.
Okay, so you're going to go to an inpatient program today, and what will happen is you're going to participate. You need to go there and do what they tell you to do, and you'll have classes and that sort of thing. And then I'm going to monitor you from time to time while you're there until you finish the program. And you said you wanted to get clean. This is a good chance for you to get clean.
Okay, can I just ask you, how long is the program? Is it?
6 months? 6 months.
Do you have options to get a job and work during that time? Or?
Yes, eventually you will.
Yes, at some point you will.
And they don't work at restaurants, they work at like KDMC, like our people work at like really good jobs.
Okay, so is that what you want to do?
Yes, sir.
Okay, I'll order it that you be released to Bethesda on a signature bond of $2,000. We'll come back and I'll get a report as to how you're doing. Let's make it a couple weeks. The 30th, are you available?
Yeah, 30th sounds good.
October 30th for a pretrial.
And I will continue to try to get a hold of her mother. Is there, well, I'll call down there and ask her if there's another number.
Is there another number where your mother can be reached other than that cell number you gave?
What day is it today? Monday?
Monday, yes.
She usually sleeps really late on Mondays. She should be up at around 3 or 4.
I'll try to give her a call later this afternoon, Your Honor.
Okay, your lawyer's going to try to get in touch with your mother and let her know what's going on. Is that okay with you? Or would you rather her not know where you are?
No, I would let her know.
Okay. Yep. You'll communicate with her then.
Yes.
I'll see you in 2 weeks. Get a good report. Do what you're supposed to do.
I appreciate it.
Okay.
State of Ohio versus John G. Atkinson here at court, case number TRC 23-15-12, A and B. Scheduled for arraignment, Your Honor, but I don't believe he's here.
John Atkinson is supposed to be here for an arraignment today. He was ordered to be here this morning, noon now. He's failed to appear, so there will be a capias issued to State Highway Patrol for his arrest.
State of Ohio versus Freddie L. Adkins, case number CRB 23437. Freddie Adkins.
Mr. Stratton's case, set for pretrial.
May I approach, Your Honor?
Yes.
Yes, because she said she made a report and then tried to raise him, get the phone, and she was
Okay, now's your chance to talk to me.
Let's see what it says here.
You said you wanted to say something to me? According to the report, I don't know if that's correct.
Your Honor, this is a DV. If you recall last time he was in court that he tested, you had him test, and he tested clean. I believe he would test clean today also, but I believe he also has. This is what he's talking about right here. But I'll let him speak for himself.
I started a new job, Your Honor. I work 7 days a week. I'm on call 24/7. We were on road service. I could be 3 to 4 hours away at the time they text me to come take these drug tests. Most of these drug tests have failed because I did not take them. I could not make it there in the required time.
Well, maybe we just need to set this for trial. I mean, he's not doing anything he was agreed to do or was requested to do as far as counseling goes, so it's not happening.
And apparently there's been more problems. So,
Okay, let's just set it for trial. You want a jury?
Yeah.
Do what?
Do we want a jury or not?
That's up to you.
You ain't done nothing else the whole time I've had you.
Yes,
Get
Your
another
Honor.
lawyer.
No. You can hire another lawyer.
Okay, I'll do that.
Job to do that.
I'm sorry?
I said, gotta have a job to do that.
I do have a job.
He just quit his job.
Go back Monday. I've already talked to him.
You can hire a lawyer at any time, but if you want a court-appointed
It's
lawyer.
kind of hard to hire a lawyer whenever you don't have money, when you have a gambling and a drug problem too.
Well, he says he wants to hire another lawyer, that's up to him. If he wants to do that, that's fine.
Your Honor, I just set this for a new date. That I asked for another pretrial date. That way his other attorney could be here for that pretrial prior to a trial date.
All right, agreed. October 30th, we'll set it for a pretrial, and I'll set a trial date at that point.
Thank you, Your Honor.
It's not resolved. No, not yet. I mean, he hasn't hired anybody else.
State of Ohio versus Daniel Hackworth, case number CRB 23538. Daniel Hackworth. Daniel Hackworth, did not check it.
This is Mr. Stratton's case set for pretrial.
We haven't signed the document. He just thinks that.
we needed to have it recalled and he's walked out, so, or we needed to add something. I don't know if he could be rounded up.
Let's go get your client, please.
I have the text messages of him saying that. I have everything. Bo was actually the one that came first, and then, Officer Chin, Matthew Chin.
Your Honor, they're looking around the way.
Go out the parking lot and see if he's coming. Freddie Adkins.
A new charge.
He thinks this is a game. Jail is a game.
I don't see him. And I know Josh. Okay. We could just recall that in a minute.
Okay. All right, we'll recall Mr. Atkins' case.
State of Ohio versus Cody Smith.
Did we do anything on Hackworth that you just called?
Daniel Hackworth, 23,538.
Yeah, I don't, yeah. So Mr. Hackworth is not here, Your Honor.
Can I approach, Your Honor?
Yes.
Just 1 second. This is Mr. Smith, Your Honor.
This is Smith.
Mr. Smith, yes.
All right, this is Cody Smith. On Daniel Hackworth, he's not here. We have no idea where he is then, Mr. Schreiber?
No, I do not, Your Honor.
Okay, there'll be a bench warrant issue for failure to appear for Daniel Hackworth.
Yes, you got bridge for all common please once.
Cody Smith is case number 23-210, 22-2099.
Your Honor, if you remember, Mr. Smith has felonies pending. Apparently, is that a final pretrial, just a pretrial? He goes.
It's a final pretrial.
Final pretrial. Yeah. He goes for a final pretrial on Wednesday with Roger Smith, so.
Okay. So that's this coming Wednesday?
It is this coming Wednesday? Yes.
And my mind, yes, that's correct.
Now, is he inpatient or outpatient?
He is.
Inpatient.
And he's also on a monitor.
Okay. Well, let's come back after that then, 30th?
30th, yes.
October 30th for pretrial.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor. State of Ohio recalls Freddie L. Atkins, case number CRB 23437.
Okay, so state wanted this recall.
And, Your Honor, I apologize for not being able to get the words out fast enough before, but there's, in all likelihood, going to be a new domestic violence charge coming forth here. And we're checking on, it was Deputy Chin who has made a report. We're told, we haven't confirmed it, but we believe it to be true. And is she still here?
Yeah.
We need to have the protection order.
Ma'am, would you come up and stand by the...
She does want a protection order, Your Honor.
Does or does not?
Are you Claudia?
No, Brooklyn.
Brooklyn Rieger.
There's a Claudia Crank that's a complaining party in one case.
No, I don't live there, Honor. She fucked her stepbrother.
Been on you for 4 years.
She's a cheating whore.
Was there another charge I'm missing then?
Yes.
Oh, Your Honor, yeah, we asked for that name to be amended previously on 23 CRB 437. We had the wrong name in there. So the name should be Brooklyn Rieger.
Okay. I didn't make any note of that, but that is Is there any objection to an amendment to the complaint?
No objection. And we'll sign, he'll sign a protection order, Your Honor.
Because there was never a protection order issued either, but you want one now, man, is that correct?
Yes.
And it's Brooklyn Rieger?
R-E-G-E-R,
So, Mr. Atkins, you'll be ordered to stay away from, not go around, not contact Brooklyn while this case is still pending.
16.
No worries, Your Honor. She sleeps with her stepbrother.
Well, that's none of your concern. I'll sign the protection order when you want, will we keep that date of October 30th?
Yes, Your Honor.
All right, October 30th is the next hearing for pretrial, 10 o'clock.
She'll bring out a copy of this protection. Okay.
Listen.
State of Ohio versus Pete Ramin, case number CRA 23-420, CRA 23-431. Mr. Steiner.
May I approach, Your Honor?
Yes. Okay. Sounds like there's still stuff you're working on.
I did.
But overall, I would say a positive report. How old's your child?
She's 8 years old.
Okay. She's with her mother?
No, she is with foster family.
Okay.
She's being adopted.
So they terminated your parental rights?
Yeah, and the only thing they're giving me is a chance to be in her life and be at visitations.
All right. Well, I don't have any knowledge or information on that because I've never done that kind of work. I don't know. Did you have an attorney in those proceedings?
Yes, I did. Mr. Gold.
Okay.
It's been a long time ago.
No, it's Gold in West Virginia right
Go,
now.
they said Hill.
Okay. All right, it's not, it's in Campbell County?
Campbell County, sir.
So it's going to be around the first of the year when he finishes up? December 22nd?
Let me check my calendar, but I don't think there should be a problem with that day. No, that day's available.
All right, hopefully you'll be about ready to transition to the next phase.
Yeah, I'll stay an outpatient and everything, look it up.
Thank you, Your Honor.
December 22nd.
Thank you.
State of Ohio versus Bobby Johnson, CRA 23-235. Bobby Johnson.
Mr. Steyer's case, come here.
Is your son here? Come up, please.
Next week, he's done a job now, he said he'd be up on Thursday next week.
Please say how long it might take.
He said within 2 weeks he'd have it all figured out.
He's saying it should be about 2 weeks to get the cleanup done. That's what's good. Where you just, 4 months.
We just gonna need the.
Okay, okay.
So you want to come back?
He's from Lexington. He lives in Lexington.
Okay.
And he's
All right.
been up, looking at the car and
Yeah.
everything else. I guess he does this kind of thing. He's in the process of finishing one site that he's at. He said it'd be done there in about 3 or 4 days and then he plans on making his way to Dad's
Could
house.
you write that down while I'm talking to the judge? That's the guy that's doing the cleanup.
He can have that, I got no.
Where's your,
I got a picture of it.
where's he gonna go after he leaves his house?
That's something I not own it after tomorrow.
You're not allowed that after tomorrow?
I not own it, the auction.
Okay.
I'm losing it at the auction, so
Okay.
somebody can own it.
Well,
But I mean, I still have the right to get my car off.
sure.
Just helps the future owner.
Yeah. He's saying he's got to be out tomorrow. He's got to start tomorrow.
The auction's out tomorrow.
Well, okay.
Right, like it'll, the way that I read it, I was working on the paper, it was from the first to the 17th, and then the second part of the auction goes to the 31st.
So we have a little bit to get out.
I looked at it last night, and sell it like 53 or 50 change, and the highest bid right now is like 24,000. It goes to the auction. So I don't know how they work to do that stuff.
So, Your Honor, there've been some changes since we were here last. Number one, they have found an individual who will help them with the cleanup of the property. And also, I guess, the property itself is going to be auctioned for back taxes in the near future. So it looks like between those two things, we might resolve the problem. So we would like to come back in about a month to make sure that this is completed or see where we stand, and we'd ask for a time waiver.
And we would certainly give any time waiver that's required. That's not a problem, Your Honor. We've placed some of my cases on the 20th and the 13th. Either of those days would work.
Okay, November 20th.
Thank you. Good luck with that.
State of Ohio versus William E. Smith Jr. Case number CRA 23327 A and B.
Thank you.
Mr. Stiers' case. Mr. Smith is at Bethesda.
Matt Fretcher.
Yes. some evidence of some alcohol use?
Yes, Your Honor. We believe that happened on passes. He's accepted responsibility and we're addressing it.
How's the state want to proceed?
We are willing to allow Mr. Smith to address these things with Bethesda and hopefully get better reports going forward.
Again, Your Honor, we would continue to waive time constraints to accomplish that.
November 13th?
I'm available, Your Honor.
November 13th for preliminary hearing.
Thank you, Your Honor.
Thank you.
State of Ohio recalls Jonathan R. Mays, case number CRD 23518.
Mr. DeWater's case, pre-trial. This is one we were waiting to see if Josh Hay was going to be here.
Yes, and I think he did show up. Your Honor, even though, it's my understanding that even though the agreement to resolve all these cases involved dismissing this one, that the complaining party is not in agreement with that now. But even though he's already taken advantage of his favorable resolution. So we can, if the state intends to proceed with this charge, I suppose we could file a motion to enforce the plea agreement, or just set it for trial. It's open to us either way.
Let's see what the state wants to do.
Well, Your Honor, there's a couple, at least two situations, aspects of this that I think require us to have a special prosecutor. Not only this situation, but other cases in common pleas court. So I think that we're going to need to request that.
So Mr. Hayes' case is going to be reinstated in common pleas? Is that what you're saying?
No.
Because I thought wasn't there a link between this case and the case in common pleas?
Well, I don't think that they were the same incident, but the same people.
Okay.
But there was apparently I wasn't part of any of that, but apparently there was no agreement that this case would be dismissed upon an agreement in the other case in which Mr. Hay was the defendant. So, and Mr. Hay said that there was not, and he wants us to proceed with this. And they are separate incidents, but they involve the same parties, and I believe that one of the two has pending charges in common pleas.
My client does.
So he's got.
There's no special prosecutor on that either. We'd waive any conflict, by the way.
Okay.
We have no objection to waiving any conflict.
Mr. Hay did. So we're okay for the time being to continue on.
And then if we could just set it for a bench trial on the 20th, it'll take literally, it shouldn't take more than a half hour, 45 minutes.
All right. This matter will be set for a trial to the court on November 20th at noon.
Okay. Yes, sir. Can we do a protection order?
Thank you, Judge. Thank you.
Is there a protection order?
We're going to ask for what?
I mean, as a condition of law, that's again, but there's a protection order on him, it's him calling police. That's do you see what I'm saying? So,
We would ask for the,
condition of the
why
bond.
can't we do it?
I mean, I guess we can.
We'll ask for protection order.
Any objection to the protection order?
No, that's fine.
Okay.
Which
issue a protection order for Mr. Mays to stay
I think
away
there
from
already
Mr.
is
Hay.
a protection order directing him not to have any contact with my client, so.
Well, I can't issue a protection order, but I'll direct Mr. Hay, let's make that mutual, stay away from Mr. Mays also.
Well, there already is one. There's already an order out of common pleas directing Mr. Hay to have no contact with Mr. Mays, so.
Is that a part of the resolution of that?
Yes.
It was.
Yes.
Preparing protection.
Yes.
Soon? Yeah, okay. I'll talk to you next week sometime or this week, whenever you stop by.
State of Ohio versus Shelby N. Rodriguez. Case number CRV 23396, TRC 23816, A, B, and C.
He was supposed to be here Friday, Judge, and didn't make it. He's turned himself in here, come to court today voluntarily.
All right, any explanation for missing Friday? Is that case?
Oh, he says he thought it was today. I'm here the 30th, Judge, if we could set it for then.
Cancel the warrant, it's here today. Set it at the defense request for October 30th for a pretrial. 10 o'clock.
I did October 30th at 10.
State of Ohio versus Amy Jo Piles, case number CRV 17280.
Okay, this has been set for sentencing for today.
Apparently I missed Friday as well. I'm just always used to coming on a Monday. I'm so sorry.
Okay, you did make a payment today.
I did. And if we can make my days off is Monday. I just didn't even think to ask the last time.
Okay, I'll set the next hearing for November 20th.
20th?
Yes, ma'am, and that'll be, I think that's you have a, yes, you do have a monitor. November 20th at 10 o'clock for
All right.
sentencing.
Thank you so much.
State of Ohio versus Destiny Anderson, case number TRC 222665, A and B.
Okay, this was set for a review hearing earlier. She is here now. And I do have a report from Mahajan. Okay, you just forget the hearing this morning, or?
No, I thought that it was at 10.
Oh, okay. All right, well, you're here now. The report's pretty good, so I'll cancel the warrant. You still have community service and fines and costs to pay.
I haven't paid my fines. I have done my community service, but
Have you turned in the hours yet, or?
Denise said that I need a paper from the court that she has to sign.
She must be doing the dog thing now.
Okay,
Yeah.
see Mr. Cooper, he'll give you that paper.
And then with my fine, my car got totaled a couple months ago, so I'm just now paying all that.
Okay, we'll work with you.
Getting caught up.
And do you have a job now?
Yeah.
What's better for your work schedule? Does it matter what day it is? Mondays or Fridays?
Either one.
November 27th, that's a Monday.
That works.
9 o'clock, November 27th. Go talk to Josh.
State of Ohio versus Brenda L. Griner, case number TRC 222709, A and B.
This is Mr. Kermeen's case.
Yes, Your Honor.
She's in Reeves.
That's correct. I put a certificate of completion in there, as well as a letter from April Withrow, and then I believe there's also a progress report as well.
May I run?
Yes.
Your Honor, last time you were here, you'd indicated if everything was good, that we could likely conclude this case, and I think now that she has finished the program, that would be the case.
Okay. This is an OVI filed as a second offense with a high test score.
And what we had discussed, Your Honor, prior to, and I believe the court approved it, was if my client did treatment, it would be treated as a first load test, and she's done all the treatment that's been asked of her.
Is that correct?
That's my memory, Your Honor, and she has been through a substantial amount of treatment. She pled guilty back in April, and we spoke about the necessity for her to be, to go through treatment and to maintain her sobriety and hopefully not get back in situations like this again. So that would be our recommendation today.
Okay, before I conclude things, I'd like for you to do a urine screen here at the court. So do a urine screen here, and then come back and we'll finalize things.
Thank you, Your Honor.
Go to the probation office.
State of Ohio versus Joshua Hay, case number CRB 21-324. Mr. Morford's case.
All right, this is set for sentencing. Mr. Hay. He had been amended Reeves. He had a case pending in common pleas. I think that's over now.
Yes, Your Honor.
He still has fines to pay here. That's what I'm showing. So what happened with your common pleas case?
I took 2 years probation.
Are you getting treatment anywhere now?
No, Your Honor. I had an assessment done through LCR, and they told me I didn't qualify for any of their services.
Okay. Do you have payment on your fines today?
Not today, I don't.
Okay, when can you pay?
It'd be the first.
Are you working? Do you have a job?
I'm disabled.
Okay. Set your next hearing for November 6th for sentencing at 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Christopher Thomas, case number CRB 23285.
All right, this is Mr. Morford's case. And Mr. Thomas was speaking, Jeremy, about ARC.
Yeah, we got him in the inpatient bed. He's scheduled. It's kind of far away. It's out near Louisville, so he has to be there at 2 o'clock tomorrow.
Okay.
Can he do blue jeans for
Yes.
his next appearance? Okay.
You can. So this takes care of your housing issue too. Okay, let's schedule it for the 30th for review. And he can appear by teleconference, as long as he's still at ARC.
November the 30th.
October 30th. Okay, good luck.
Thank you. Thank you, Your Honor.
Thank you, Judge.
Thank you.
Okay. All right, Mr. Major is on his way, so he will be here shortly.
State of Ohio recalls Derek C. Willis, case number TRC 22160 A, B, C, and D, and TRC 14901 A and B.
Judge, I was able to reach Mr. Willis via text message. He indicated to me that he was working in Florida. He said he was here the other day and he thought he paid off all the fines. He also believes he completed all of his community service. However, he was supposed to get together with Mr. Major and did not do that because he went back out of town working. He asked me if you would give him some time to get together with Mr. Major. He thinks that that's completed also. Now, I haven't looked at the file, so I don't know if any of that's true.
I'm showing he still owes $685 on 22-160A.
No, it's paid.
Oh, it is?
Yes.
Okay.
I didn't get the other case number, if you'd give it to me, please.
Well, it looks like that was paid too, 14901. So it looks like the fines are paid. I'm not showing community service.
And Mr. Willis indicated to me via text message that he was supposed to get together with Mr. Major to clear that up, but he has not done that. He hasn't had an opportunity to do that.
When do you want, I'll continue it for another hearing. When do you want to come back?
Well, is the 20th of November too far out?
No.
Okay, and that way I know I'll be here, and if he wants me to be.
And that's the week of Thanksgiving, so probably has.
Oh, boy.
He needs to go to Grandma's house for Thanksgiving.
Thank you, Judge.
Come in for Florida, November 20th for sentencing.
Thank you, Judge.
You're welcome.
Judge, we called a case earlier, State versus Jet Porter. It's one that we just got discovery on. We set that for the 20th also. Mr. Porter and his family advised me after court that they had plans to be out of town for that week. Rather than move it, can we still have a pretrial? And if I need him, I can get him here via video. I think it's just going to be me discussing with Mr. Hill the issues in the case.
I have no objection if the state has no objection.
We don't object, Your Honor.
Okay, thank you,
Keep it
Judge.
on the 20th.
All right, thank you.
State of Ohio recalls Donald Dickus, case number CRA 23104, CRD 23105.
Mr. Dickus was here for review. We were looking for a report.
Your Honor, for some reason, we keep faxing it here, it's not coming through. I don't know what the deal is. I can give you a verbal report. He is engaged in services, never misses a screen. The screens aren't, he's working on them. We're still struggling with alcohol, but he's at least engaged in treatment and he's trying.
Okay. I'll take that. Let's come back on November 27th.
I'll see you the 30th. I'll be here the 30th.
Oh, for another case?
Yeah, I'll be a witness.
Okay, well, we'll keep this as November 27th. It's not your case, though.
Yeah.
You're right.
All right.
Thank you, Your Honor.
Thank you, sir.
You're welcome.
State of Ohio recalls Aaron Sloan, case number CRA 23368 A and Z, CRB 23369, TRC 23750 A and B.
Aaron Sloan, Mr. Morford's case.
I'll defer to my colleague, Your Honor.
I spoke to her on the phone. Her daughter caught COVID last week, and now, unfortunately, she has it. She said she had meant to call the court Friday, but things have been so hectic with trying to take care of her daughter who's been really sick that she didn't call. I told her I would try to get this set out for another date.
All right. October 30th, Mr. Morford.
That's fine, Judge.
At defendant's request, October 30th, 2 weeks from today. Preliminary hearing and review.
So she needs to be here at 9.
We can make it 10.
Thank you, Your Honor.
Thank you, Judge.
State of Ohio recalls Brenda Griner, case number TRC 222709, A and
Okay. Good screen, so we can go ahead and conclude things.
Never doubted it for a second.
All right, so this is case number 222709. 222709. Anything you wish to say, Ms. Griner, before I finalize things?
That you'll never see me in here again, or any courtroom, that is, so.
We're gonna do the first offense.
It'll be a first offense. You do understand that if you did get an element, it could be followed as a third offense, which jumps up possible penalties quite a bit.
Yeah.
Okay. I'll give you a $600 fine where you pay court costs, 6-month license suspension, which is going to be over by, it's already concluded. But you will need to contact the B&B to get it reinstated. I ordered you to do 5 days of community service. 2 years of, we can make it level 5 probation, since she's done most of what she needs to do. I'm going to delete the driver intervention program also, since you've already done quite a bit of counseling. You won't have to do that 3-day school.
Thank you, Your Honor.
Set her review hearing for April the 15th of '24.
April what?
Finish everything, you don't have to come to that hearing. On the lane violation, it'll be a $10 fine. She needs to meet with Mr. Cooper. And then she's free to go.
Thank you, Your Honor.
You're welcome.
Thank you.
State of Ohio versus Jeremy A. McMillan, case number TRC 22769, A, B, and C. TRC 202410, A, B, and C.
Jeremy McMillan is here with his counsel, Roger Smith.
They're all good, all right.
And Seth Bethesda.
Well, you're left. Yeah. Positive demeanor, negative drug screens. Committed to recovery. Give us more, man. I'm not going out with my pen back.
Okay, excellent report, Jeremy.
Thank you, Your Honor.
Back, I think I'll take a copy of this and send it to Judge Ferguson.
Sure.
I think that'd be great, Judge. That's a good one.
So, that's what I wanted to see.
17 and a half.
So, do you still have to report over there, or what are they doing? They just put you,
The first Thursday of every month until I make it to sober living. They can't give me a temporary address in-house. I have to make it to there.
who's your, what's the name of your probation officer?
Jennifer?
Browning.
Browning it.
Yeah.
So Jennifer not Browning it. Something.
She's the chief probation officer.
You know what?
Phone number.
I send,
You've said to Jennifer Browning, she's the chief probation officer.
What's the address to get?
It's the basement of the courthouse at Huntington.
If I just send it to Judge Ferguson?
Oh, yes,
Would
yes.
that be sufficient?
And she'll get a copy of this too.
I think he'll send her a copy automatically.
Okay. All right. Good work.
Phone number.
Doing really well. Keep it up. And make me look good. Judge Ferguson. He's about to retire, though.
He is,
this,
yes.
This year, is this
I
it?
think 24, he's not going to run
Oh,
again.
one more year,
so-
okay.
Yeah. They don't have age limits, he's 86.
I know.
He went to school with my dad.
He doesn't look,
No,
doesn't look 86.
people are shocked when you tell them that.
He does not look
No,
86.
he and my dad were in school.
Man, oh my.
Okay. I want to see you after Thanksgiving.
Sounds good.
So we'll make it the 27th, November 27th.
I'm here that day, Judge.
Okay, November 27th. Good job, Jeremy.
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus Brock C. Smith. Case number TRC 20-1599, A, B, and C, and CRA 2706.
What did you have to do?
I've done it all.
I believe he's,
I don't even know why I'm here.
you completed your community service. Did you have any community service to do?
No, they're saying I had some from 2002.
Okay. Your Honor.
This is Mr. Stratton's case set for sentencing.
Your Honor, I believe he's done everything he was supposed to do. Sentencing was quite a while ago, last summer, wasn't it?
A couple of years ago.
Yeah.
Well, he's got it's put on the sentencing document because he's got a bond now.
Yeah. But
That was from this summer.
he just needs to know what he needs to do to complete the case. Maybe some, I'm not even sure what he needs to do. He doesn't have any community service to do.
Mine's nothing.
I think everything's paid.
Yep.
I think everything's paid, so.
Well, I think we were looking for a report. I've got a report from Brightview. I don't have a completion letter. I think that's the problem. He was supposed to be going to Valley Health, but then I got something from Brightview in Portsmouth, July 14th, saying he's being treated here. He will be on site weekly until further notice. That's the last thing I've got.
Was that July?
To do a drug screen, July 14th, and they tested positive for amphetamines, buprenorphine, and THC.
Was that July of this year, Your Honor?
It was.
Okay.
So I'm just looking for a completion letter.
I don't have nothing like that.
That he completed treatment somewhere. He was, actually, he was ordered to go to Valley Health. And
Okay.
he did not complete there, I'm going to take it. And then,
Fuck all that. Why don't you take
No, I'm just trying to get the case.
and he was,
done with this?
he was out of pocket from October 14th of 22 until July of 23. And I think that's when, yeah, that's when he got arrested on a warrant and got kind of drugged back in here.
Okay.
A warrant for
And
what?
that's actually when he paid off the last case, it looks like. Yeah, he paid something on one case and a warrant fee on the other. So I just need a completion letter.
Did you complete that?
Your Honor, if I may, his mom told me this morning that he'll
I'm
be
still currently in it.
ongoing in
How you
treatment
complete a program you're in?
for,
Are you in treatment now someplace?
Yes.
Where?
Brightview.
Okay, I need a report from them. haven't had a report since July 14th when you came back the first
So I
time.
need to come back again.
Do you have a completion date with Brightview?
No.
Your Honor, it looks like it's an ongoing thing with Brightview.
Well, he shouldn't get too animated, because I ordered him to go to Valley Health, and he switched on his own to Brightview. The court did not order that.
Yes, Your Honor.
He was out of pocket for 8 or 9 months, where he did not appear in the court when he was ordered to, and then he got arrested on the warrant.
Your Honor, if we set this for another date relatively soon, we'll have a letter from Brightview and hopefully something from Brightview as to when they considered him completed, maybe even a history of how he's been doing at
Yeah,
Brightview.
here's what the last, I mean, it's very non-detailed. The last letter from Brightview, it's all of 2 sentences. To whom it may concern, Brock Smith is currently active in Brightview program. Sorry, it's 3 sentences. He will be seen on-site at weekly frequency until further notice. If you have questions, please reach out, gives a phone number. That's it.
Your Honor, we'll make sure to have a more detailed letter as to what he's going through, how he's doing.
How much time do you need to get that done?
Your Honor, you prefer Mondays or Fridays?
Monday.
Monday in a couple weeks, Your Honor.
October 30th is 2 weeks. The sentencing, October 30th at 10 o'clock.
Need a detailed letter from Brightview, okay?
And then it'll be over.
Well, I need to know what's in the letter. So if the letter says you have a conclusion, you complete, you have to be good.
What am I facing?
State of Ohio versus John Riggs, case number CRB 23528.
All right, John Riggs is set for sentencing.
May I approach, Your Honor?
Yes. So he's inpatient now at OBP.
Yes, sir.
Yeah, just to provide some context, this was the client I messaged you about that had the severe health issue that we had to transfer over there so they could have oversight over his PIC line.
Okay. So he's going to be there till first week of November.
Yes, I still have IV antibiotics. I had back surgery the day after I left here. I went to the hospital, I picked up my little girl, and I was paralyzed on the right side, so I was in Cabell for 2 weeks and had back surgery, and so I went to inpatient.
So he'll be at OVP until he completes his IV antibiotics, which it could go past the 4th.
Okay.
So it'll just,
Well, why don't we come back on the 6th then and see
Okay.
where we are. I'll set your next hearing for November 6th.
Yes, sir.
As a sentencing, 10 o'clock. What about your job? You had a job?
Well, my boss came to see me twice in the hospital, and he's still supportive. I've been clean 28 days now.
Okay.
I feel great. I'm just getting through the medicine.
Sounds like you're on the right track then.
Thank
So
you.
you need to get that job back, I think.
Yes, he's really, as soon as I'm able to work, he's gonna get me back to work, so.
Okay, very good.
thank you, Your Honor.
Thanks, Judge.
State of Ohio versus Joshua Carter on a recall at the Lawrence County Jail, case number CRA 23599.
All right, can we let Mr. Morford go talk with Mr. Carter and then recall this? The state wants to go ahead and take it on to the grand jury.
We're going to waive preliminary hearing, Judge.
All right, is that correct, Mr. Carter? Yes. All right, we'll send down a waiver for you. Bond is now $10,000 cash or surety. Case is waived to the grand jury. We'll need a waiver and have Mr. Morford sign it, and then we'll fax it to the jail.
Thank you.
The time frame on him, I think, you wanted to know when the bond, or you need to know when the arraignment occurred, or when does that start?
What I'm doing with my phone.
Looked like the arraignment date was October 6th. On Joshua Carter.
You still have this active
No. They won't take him into jail or anything. Did Mr. Thompson leave? I wanted to do something on this Seth Harrison. Guess we can put it on the docket.
Oh, boy.
State of Ohio versus Corey Little on the recall from Orange County Jail. Case number CRA 23617, CRA 23605 A and B. CRB 22491, CRA 22405.
Mr. Steyer's case, and I guess we're going to do, it's like we're having a preliminary hearing.
Yes, I think so. Mr. Major's back.
All right, Corey Little is at the jail. His lawyer is here in person. We're going to have a preliminary hearing. The state ready to proceed.
As soon as we have Mr. Major.
He is here.
Right. Is that
Apologize.
Mr. Major, if you'll take the witness stand, I'll swear you in. You swear that the testimony you're about to give shall be the truth, the whole truth, nothing but the truth, so help you God.
I do.
You may be seated. Mr. Hill.
Thank you, Your Honor. Mr. Major, state your name and where you are employed.
John Major, I'm the probation officer for Lawrence County Municipal Court.
And in your role as probation officer with the court, are you familiar with Corey Little?
I am.
Do you see him on the screen there in the courtroom?
I do.
Can you point to him, please?
He's on the top right.
Record show you pointed to the phone.
There's been a couple charges filed. One of them tampering with evidence and vandalism going back to October the 2nd, 2023. And I believe you were the complaining party in that. Can you explain what happened?
Yes, on September the 29th, Mr. Little was released on bond from the Lawrence County Sheriff's Office to go to Bethesda for drug and alcohol treatment. Part of that bond was he had a GPS monitor placed on him, and that would be monitored by the Lawrence County Common Pleas adult probation. On 9/30, on September 30th, I was advised by Bethesda that he had left their treatment against their advice and without permission of the court. And then later that night, I was contacted by representatives from the Common Pleas adult probation that they had what they call a strap tamper, which means that the strap holding the GPS monitor on his person has been tampered with, cut, trying to be removed. Then I was contacted
by adult probation on October the 3rd, and to see if we could go to the last known location and see if we could locate the monitor, and we did.
Where was the monitor?
It was in a vacant lot in Huntington, in a overgrown area by a fence.
Now, Corey Little was at Bethesda at the time. Did he cut the monitor off there at Bethesda?
I'm not aware that that's where it was cut off of.
Okay. And that place where he was at Bethesda was in Union Township here in Lawrence County?
I'm not sure where the actual facility is, but the order for him to be put on is here at this court.
So you found the unit and it had been tampered with?
The strap had been cut with some sort of an item and removed from the person.
That's all I have.
Mr. Stein?
Mr. Major, you stated that you were asked to go to try to locate the monitor. It's the last location where it signaled?
Yeah, that is correct.
And that last location was over in Huntington?
It was.
And how exact were the coordinates they gave you to go to? Did they give you GPS coordinates or an address or what?
Actually, Eddie Spears, a probation officer for the Lawrence County Common Police, went with me, and he had a printout of the last location and where it would be located in Huntington.
Was that a printout, was that information in the form of an address or GPS coordinates?
He gave me an address. I don't know how he came about it. He had the information.
Did you meet Officer Spears there, or did you travel with
He met
him?
me here at the court, and then I followed him there.
Okay.
And he gave me an address we were going to look at.
Okay. And as far as you're aware, the monitor was found exactly where he expected to be found?
Yes.
It wasn't down in a sewer drain or something?
No, it was an overgrown area and high weeds.
Okay. Those are all the questions I have, Your Honor.
Mr. Hill?
I don't have anything else, Your Honor.
You may step down.
We rest.
Your Honor, there's not been any testimony that any criminal acts took place in the jurisdiction of this court. The testimony seems to be that the monitor was tampered with. We don't know where the monitor was tampered with. We don't know that that happened in this county, even let alone in one of the townships that this court has jurisdiction over. And to the degree that leaving it in that field even is tampered with evidence, that field is over in West Virginia, so that act took place in West Virginia, also outside the jurisdiction of this court.
I'm going to find there's sufficient evidence for probable cause that a crime was committed here. You can make that argument after the grand jury. I'm binding over Mr. Little to the grand jury. I'll keep the bond the same at $25,000 cash or surety. That's on 23-617. He has a bunch of other cases too.
There's another case that's set for preliminary hearing today, but I think the state may have a motion on that one.
23-605. That, okay, wait a minute.
Actually,
23-605 A and B is the one I'm bonding over.
the other, I'm going to advise Mr. Little to go ahead and waive his right to preliminary hearing on that because it's kind of a moot point since he's already bound over, and I'd prefer that he maintain his bond.
23-617 is the theft.
Yes. So on that, I'm going to advise Mr. Little to waive his right to preliminary hearing.
And that's the one where the gentleman wrote a very nice letter for you, Mr. Little. Mr. Campbell wrote a very nice letter to the court about you, so. And
I spoke to him this morning. He doesn't, I don't think, wish to press these charges, but I think that's obviously a question for the state. And my fear is that were I to push the issue, the state would simply nolly the charges and there'd be no bond on that, which could cause him problems down the road. So again, my advice, Mr. Little, is to waive his preliminary hearing on that matter. Is that something you're willing to do, sir?
Yeah, I guess.
Okay. 23-617 is waived to the grand jury. 605 A and B is bound over to the grand jury. Let's see, what else we got here? We've got 23-216 was a felony possession charge. It's still pending.
Right.
So it probably needs to be waived or...
Is that also a felony?
Yes.
Okay, if it's a felony, we would waive that as well, Your Honor, I'm sorry.
So 23-216 is waived to the grand jury. And then there is some misdemeanors that probably should go with it because I think they happened at the same time. Possession of a drug abuse instrument happened allegedly the same.
Yeah, we'll nolly those to the grand jury.
So that's knowledge to the grand jury.
Which one's not later on?
23. Gotta get Judge Hall's stickers off here. 23-218A is knowledge to the grand jury, as is 23-218B. Both of those are misdemeanors.
And 23-216 is waived?
Yes.
Okay, anything else waived?
Well, let's go. He's got a stack. 22-491 is a misdemeanor. Let's see what it is. Violation protection order. It's old from July of 2022.
Your Honor, the misdemeanors, I think there are a number of misdemeanors that are going to remain here. The situation, though, is such that I would guess he's probably not going to get before the grand jury he might get in there this month. It's going to be next month before we get him into common police court, most likely. I think he has a defense on the charge that he's facing that's going up there, but if he is convicted on the tampering and the monitor cut, that's likely going to result in a prison sentence. With that in mind, I would ask that we just continue these misdemeanors out a ways with the hope of maybe that if things are looking like we're looking toward something happening up there, we might be able to wrap these in. And we would waive time constraints to accomplish that.
He's probably right. That's probably the way we need to do it.
Then there's, okay, so 22-491, I'll just continue, maybe come back November 27th. You think that's long enough?
Let me make sure I'm available that day. I am available that day. That should be long enough to have an idea where we're going.
Okay.
We may not have it worked out, then we'll at least have sort of a map.
22-491 is continued for a pre-trial to November 27th at 10 o'clock. And digging back into further old cases, we've got another possession charge back in 22. June 21st of 2022, there's an F5 possession of methamphetamine that's still unresolved. Do you want to take that to the grand jury?
Might as well, yes.
Might as well. And there was, same day, a domestic violence with it. So that would be knowledge to the grand jury. The victim on that is Debbie Wellman.
Well, we got a cross-filing on that. Why don't we, let's leave that one here.
Okay, and the felony too?
We got plenty going over to the grand jury. I don't know.
You want to stack them up too high?
This had gotten somewhat cumbersome for me to keep track of everything. I feel kind of bad just putting it over on the people at the common police court, but we probably should go ahead and do that, nolly that.
Okay, so 22-405, you want to nolly it, or again, you want to waive that one?
We would waive
Another possession charge.
Yes, we would waive that to preserve the bond.
So 22-405 is waived to the grand jury.
Is that an A and B or just?
It's just the name, it's nothing, it's a 22-405. 22-407, then you want to keep it here. That's the domestic violence that happened the same day, or you want to nolly it?
I think we leave that one here.
Okay, 22-407, stand here, we'll set it for November 27th. I'll I'll make a note, CRB 22407 only. CRA waived to the bank. Okay, another one. 23, 194, and 195, these are both misdemeanors.
Yes, we are. It doesn't mean it's going to go to the
Violation of protection order. This is from March of 2023, March 26th and March 28th. 2 violation protection orders, and the complaining party is Debbie Wellman. She was a victim of a lot of domestic violence. What do you want to do with those?
Are those all misdemeanors?
All misdemeanors.
Leave those here.
Okay, so those are set for November 27th. For pretrial at 10 o'clock. Okay, I think that takes care of everything.
Thank you, Your Honor.
You're welcome.
45.
I'm sorry?
Do I have a bond?
25,000.
Yes, 25,000, cash surety still covers everything. That's why we wanted to waive things to the grand jury. We didn't want you to bond out on something and have something out there without a bond set, you end up getting picked up on.
Are you Mr. Campbell?
Yes, sir.
Nice letter, sir. Thank you for your,
So.
maybe more helpful than Mr. Little deserves, but it's nice to know people like you exist that want to help. So thank you for your letter.
So what exactly, you're going to have a $20,000 library out there that's promoted?
That was posted before the most recent charge.
You got a new bond, 25,000.
The most recent charges happened after that bond was posted. So that bond can't be extended to these charges because they didn't exist when it was posted.
So I got to post another one.
Yes, but you can post a bond that will cover everything.
Okay, I guess. In the meantime, is it possible to go back to Bethesda and get some kind of help?
Well, the court would have to modify your bond to allow that. I'll make that motion now, Your Honor.
All I've done is seem to make things worse.
I don't know, this would be the third time.
You're out between parents dying and things happening and just what get out of control. I just lost it. I lost my way. I did enjoy, I was there when I
Those plus this one,
we went
405.
the picnic and the rehab kickball and all that.
I was told you didn't like kickball.
Everyone loves kickball.
I couldn't move. My legs couldn't move.
Well, generally after you cut a monitor, I don't think that I think you'll have to make that argument to the common pleas that you deserve to go back to treatment. I think that's going to be a hard sell, but yeah.
No, I just figured I'd rather sit in jail and just stare at the wall. Might as well get some kind of help.
You'll have to argue that to one of the common pleas judges.
Those are all misdemeanors, they're still here.
I'm not going to do it.
We're waiting on Dave.
Okay, that's all.
What's the date of our next hearing here?
November 27th.
Here, Luke. We want the rubber.
Next in the sheriff and jail will be Cheryl Carrico. Cheryl Carrico.
misdemeanors.
And the one that's like iron or something, you can't cut off. Yeah, you got the file.
This is a record.
It's just
State of Ohio recall Cheryl Carrico, case number TRD HB 2577, A&B.
Oh, she's going to do urine screening.
Yes.
Fentanyl, methamphetamine.
Yes, sir.
We need to get you in treatment.
Yes, I would like to go to Riverside if I could.
Well, is there anybody here?
RS doesn't have female beds anymore.
Okay.
OVP is here, Your Honor.
Do you have an Ohio medical card?
I can't hear you, so sorry.
Do you have Ohio medical card?
Yes, I have one now.
Okay, I can have somebody, what's her name?
Her name is Cheryl Carrico. She's tested positive today for fentanyl and methamphetamine. She says she wants to go to inpatient treatment, right? You're gonna go to inpatient.
It don't matter.
Okay, I can have someone call down to do her assessment and try to get her in today.
Okay. I'll put you back on the docket for 23rd. But hopefully by then you'll be at OVP. I'll
Yeah, we'll
enter
be
an
able
order.
to
She
get
can
her.
be released directly to OVP for inpatient treatment.
Did you say November 23rd?
October 23rd, a week from today,
Okay.
just to make sure I don't lose her. She's sitting in the jail, nothing happened.
Right.
Sometimes stuff like that goes on. So that way we don't lose her. So if everything goes right, you're going to be in a treatment program before sunset.
I can't hear you.
You're going to be in a treatment program today, if things go
Okay.
right. And then I'll see you a week from today back on either, well, I'll get a report. You may not be here in person, but I want to make sure you're in treatment. I think she's got a pretty long history.
Okay. We'll get it taken care of. Thank you, Your Honor.
Okay, take advantage of this opportunity. You'll see you in a week.
All right, thank you.
You're welcome. Yeah.
State of Ohio versus David M. Wynn, case number TRC 222648, A&B.
Is this everything? Okay, that finishes up in the jail. Thank you.
Recording has gone.
Okay, this is set for a motion hearing today. Mr. Cummings filed a motion. What is that dispute here?
Your Honor, that dispute here would be the stop, the continued detention, reasonable suspicion to conduct field sobriety testing. I have since indicated to Mr. Heald that I will not be objecting or getting into any of the field sobriety testing. The only one originally that I had planned to look at was the HGN. In retrospect, I've decided that I'm not going to go into that, so I will get rid of that portion of it. And number 6 and 9, but solely on the basis of whether or not the state could provide the requisite, I believe it's 3 years worth of repair logs for the machine. They provided me sufficient evidence after the motion was filed of of anything else that I had alleged there.
Okay, so let me make sure I understand what we're focusing on. Was there reasonable articulable suspicion of activity sufficient for a stop of the defendant's vehicle?
Correct.
Was there reasonable articulable suspicion of evidence that would warrant getting him out of the vehicle and starting field sobriety tests?
Correct. Getting him out to conduct and beginning field sobriety
But
tests.
not going through the field sobriety test?
Correct.
And then, do we have evidence furnished of 3 years' worth of logs on repairs of the machine?
That's correct, Your Honor.
Okay, so those are the only 3 issues we've got.
And I guess in theory, just so that's kind of preserved here, the not having reasonable articulable suspicion would also, at that point for doing field sobriety test, would also then invalidate the continued detention for arrest. But I'm not directly saying, based upon, it would be cut off at that point rather than a true just, totality of the circumstances, probable cause to arrest. But if he didn't have reasonable suspicion to conduct the field sobriety, then he wouldn't have had probable cause to arrest based upon field sobriety.
I understand. All right. Mr. Chairman,
Well, there's
you
one,
understand?
I think that the issue of the repair logs is one that we won't have evidence to, as far as testimony. I don't, I'm not sure that that's something that we're required. We gave them everything that the State of Ohio Department of Health gave us in response to their discovery demand.
Okay, so what we'll do on that, we won't take evidence, but you can argue it, brief it, let me know what was produced. If there's an agreement on that, dispute on it, then I probably would need some.
Yeah, it's just the burden of production on their side of it. I've received them in other cases in the past, but in this case, for whatever reason, and a string of cases recently, I haven't gotten those repair logs.
So here's the thing, when it comes in, it's an envelope about 2 inches thick, and I guess that maybe I'm negligent in not reviewing each and every page, but I kind of count on the experts at the Ohio Department of Health to send me, because we send them the discovery demand. So I'm not sure that it's something that is, detrimental to our case if it wasn't provided, or that it keeps them from being able to defend themselves. I don't know.
Yeah, I can brief it. It's in the Ohio Administrative Code as one of the requirements.
All right, for today, then we're really only going to be on the 2 issues, the stop and whether there was sufficient evidence to go forward with field sobriety tests.
That's correct, Your Honor.
Okay. State ready to proceed?
Yes, Your Honor.
If you want to take the stand, I'll swear you in. Raise your right hand. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God. I do. You may be seated.
I'll stipulate to the videos right out of the gate. That way you don't have to worry about trying to authenticate them.
I've already written the questions down here, and I'm not going to be able to skip over. So. Trooper, could you state your name, please, where you're employed?
Trooper White, Hostile Air Patrol Honor Post.
Were you on patrol on November the 13th, 2022?
Yes.
And at that time, did you come into contact with David Michael Wynn?
Yes.
Do you see him in the courtroom today? And if you do, can you point him out, please?
Yes.
Record will show you pointed to the defendant.
And where were you when you encountered Mr. Wynn?
I was sitting stationary patrol on US 52, Milepost 21.
Is that in Perry Township here in Lawrence County?
No, that'll be in Fayette. I stopped in Perry Township though.
Was Mr. Wynn operating a vehicle at that time?
Yes.
What caused you to first notice Mr. Wynn's vehicle, and what did you do in response to that?
Yeah, so as I was sitting stationary there, the defendant passed me. As the defendant passed me, as I was washing the vehicle, he traveled over the yellow fog line. I'm not exactly sure the exact name of the yellow fog line, but and then jerked back in the left lane.
So the yellow one's the one on the left-hand side of the...
Yeah, it's not the center. I don't think it's called the center line, but it's not the white line, it's the yellow line.
After you began following him, did you see any other traffic violations?
Yes.
What did you see?
He traveled over the white fog line this time, Then he went back to the center line, weaving heavily, and made marked lane violation.
Did you initiate a traffic stop as a result of that?
Yes.
All right, so your video was equipped with, or your cruiser was equipped with video, and you had body cam, and that's all been uploaded for use in this case?
Yes.
As a result of what you saw there, as far as Mr. Wynn's driving, did you initiate a traffic stop?
Yes.
Did you initiate your overhead lights first to signal him to stop?
Yes.
You watched the video previous to today's hearing and familiar with it?
Yes.
Is this from your cruiser, and is that Mr. Wynn there in front of you?
Yes.
The first lane violation that you described, was that before you started following him, before your camera was turned on?
Yes, it was as I was sitting in the crossover, so it would not have, it would not have caught it on camera, so it was not facing the same direction.
Now, as you're going and following him here, are you witnessing what you had already described as far as lane violations and whatnot?
Yes.
Now, your lights came on there. Is that when you made the decision to pull him over?
Yes.
You had witnessed, do you know how many lane violations you witnessed?
I don't remember exactly now.
Now, does Mr. Wynn stop right away?
No, it takes him approximately 30 seconds, I believe, to stop.
In defendant's motion, he describes the stop as immediate. Do you consider that immediate?
No.
Were the marked lane violations and other weaving that you observed, would you consider those to be cues of an impaired driver?
Yes.
Was that stop time of about 30 seconds, was that also a cue that he might be impaired?
Yes.
Now, at this point, after you have him stop, do you approach the vehicle and make personal contact with him?
Yes, I think I have passenger side of it.
So when you make the approach, describe what you observed and what your interaction with him was.
Yeah, so I asked the defendant where he was coming from. After asking for his information, stated he was coming from a friend's house in Huntington. As he was talking, I could smell a strong odor of an alcoholic beverage coming from the vehicle. And shortly after that, I asked him to step out.
Was there anything then at that point that you noticed about him physically?
No, I believe I noticed his eyes were bloodshot. Can't remember if I noticed it when I was up the vehicle or if I noticed it when I was talking to him back in my cruiser.
Hey, how you doing, sir? Good. Got your license with you, sir? Where you come from there, sir? Okay. Where at night? I was at a friend's house. A friend's house? Okay. Where's your friend live? I think on like 4th Avenue. 4th Avenue? Yes, sir. Okay. Was just you and your friend? Was there other people? No, just my friend. You and your friend? Yeah. Okay. Going out to any bars or anything? Yeah. How much alcohol do you consume tonight? I have a glass of wine over there. Just one glass of wine? Yes, sir. Okay. All right, hang tight for me, Ryan. Yes, sir. Where are you trying to get to? Just like right at the creek. The creek? Okay. Yes, sir. Ah. All right, want to hop down for me real quick? Sure. Sorry. You're okay. You can sleep a wall there in the car. I appreciate it. No guns, knives, bombs, bazookas, nothing like that. Okay. Walk back in with it. Just the front of my car. Step to your left. Okay. Face my car. We'll patch down real quick, okay? Is that all right? All right, stay down here for me. Okay, hang tight right there, okay?
After you had him step out of the car, did you notice any other clues that would indicate that he might be impaired?
Yeah, I continue to smell the strong odor of alcohol beverage on his person. And I believe when it's in a few more seconds as I'm facing him, I can then tell that his eyes are bloodshot.
Well, so I understand that that's as far as the emotion is going.
That's correct.
All right. That's all I have.
Trooper White, you have been through NHTSA field sobriety testing course, correct?
Correct.
I'm going to object. I mean, I didn't think.
I'm just going through, I'm not getting into the field sobriety just through his training, because during the field sobriety course, they talk about the different indicators of phase 1 and phase 2, right?
Mm-hmm.
Okay. And you did say that you've had that training.
Correct.
Additionally, you've also had training through A-RIDE.
Correct.
Right. Now, as part of that training, you're taught to write full, thorough, accurate, and complete reports, right?
Right.
And in this case, did you write a full, thorough, accurate, and complete report?
I believe so, yes.
Okay. So you acted in accordance with your training with that, right?
Correct.
In fact, in A-RIDE training, they indicate to you that if you don't record it, that it didn't happen, right?
I don't understand positive on that. What do you mean by record it? You mean write it down?
Record it in your report.
Oh, my report?
Mm-hmm.
Okay. I'm not exactly sure about that, but.
Okay. One moment here. All right, I'm going to direct you to section 8, pages 11.
Remember, if you don't record the evidence, pay now.
Would you say that you recorded all of your observations?
Yes, the ones that I could, I mean, there was human error, but
Okay. Did you write your statement of facts contemporaneously or immediately after the stop?
immediately, no, probably not.
Okay. How long after would you say that you wrote your statement of facts?
I don't remember.
Would it have been hours? Would it have been days?
I don't remember.
Okay. So it could have been hours. It could have been days. Is that fair to say?
Yes.
Okay. Wouldn't have been weeks.
No.
Fair enough. As part of your training, you're also trained to take field notes, right?
I've never took field notes, no.
Would you
Like on a piece of paper?
would you agree with me that in the NHTSA manual that that indicate that you should use field notes, and they even provide you with a form to do it on?
We've never been provided with that form, so. no.
Okay. So, were you ever provided with a manual?
A manual?
Yes.
Yes.
And I'm going to object, this was before the 2023 manual came out, so that would not be, it wouldn't be in effect at that time. So.
I don't think we have any question about which manual it is at this point.
Yep. Okay. Nevertheless, you didn't take any field notes?
No.
Right? Okay. I want to direct you to the dash cam video. Now, to start with, you indicated you observed a Mark Lane's violation occur off camera, right?
Yes.
Do you agree with me that you have no evidence, as you see here today, of that occurring?
Just my testimony.
All right. You have no physical evidence, right?
No.
And you don't have any recorded evidence?
No.
Okay. Now, I want you to stop me when you see, because you indicated there was a Mark Lane's violation, I believe, over the fog line, and then a Mark Lane's violation over the center line, and an adjustment in between, right? Is that fair to say?
Yes.
Can you show me when that occurs?
I will not be able to do that. Based on the video, it's, as you can see, the picture's not very clear.
Okay, so you don't see when it happened on video?
Well, I have my eyes. My eyes are a lot better than the video.
Okay, what's the resolution of the video?
I have no idea.
How many frames per second does the video show?
I have no idea.
What's the maximum distance the video can capture?
I have no idea.
Okay, so if you don't know those things, how can you indicate that your eyes are better than the video?
Well, because I can see a lot better when I'm in my cruiser, then it looks like it's a lot further away than what it actually is.
So you can't, as we sit here today, you cannot indicate when that occurred?
The exact spot, no, I cannot.
Okay. So keep watching. Okay, so would it be fair to say that at 129 on the video is when you hit your lights?
Yes.
Okay. Now, going back, is it also fair to say that you cannot tell on the video where a Mark Lane's violation occurred?
Not specifically.
Okay, and you can't see him travel across the fog line on video, right?
Correct.
You can't see him travel all the way back across traffic and across the center line, can you?
There's a few spots in there that looks like it may have happened right in that area, but it's not 100% definitive. That it went across the perforated line.
Okay.
In the video, it did happen in real speed as I was there behind it, but as far as the video goes, it's very difficult to pick up marked lanes unless they travel completely off the road.
So 129, you hit your flashing lights. Now, you're behind Mr. Nguyen, but you're not as close as you normally are in traffic stops, correct?
Correct.
Okay, so at 135, you see 6 seconds later, he hits his brakes, right? So at that point, you believe he's acknowledged your traffic light. Okay, so 6 seconds went by until he acknowledged your traffic signal. He then signals appropriately, right? Consistently with what you want him to do. And then ultimately begins to pull off the road. Okay. Now, it wouldn't be appropriate for Mr. Wayne to jerk across the line and slam on the brakes, right?
No.
Because that would also be an indicator.
Could be, yes.
He signaled appropriately, right?
Yes.
Made sure it was safe,
Yes.
and appropriately pulled off the road.
Yes.
He didn't slam his brakes on once he was off the road.
No.
He didn't make other marked lanes violations.
No.
He pulled off as you would expect someone to normally pull off the road, right?
Well, in my experience, it doesn't take somebody 30 seconds to pull over after I initiate my lights.
So you've never had anybody take 30 seconds?
I wouldn't say never, but it's not common to take 30 seconds to stop.
Fair enough. Let's go through, let's talk about your training a little bit and go through what some of the indicators that you're trained on. The vehicle in motion indicators. What are the 4 categories of those? And then it's a manual.
I do not recall
Okay.
specifically.
What are the cues?
Marked lanes. Are you talking about what would we pull somebody over for, or what are cues for impairment?
What are potential cues during vehicle in motion that you're trained to look for?
Marked lanes violations, wide turns, not using the turn signal or changing lanes, excessively slow speed, varying speeds. Those are the ones I can think of at the moment.
Okay. So you named 5, right? So you were talking about your training just now. Are you familiar with the 30?
The 30?
Mm-hmm.
Every one of them? No, probably not.
Okay, well, we're going to go through them here. So the 4 categories.
Are those in the 2018?
They're in the 2018 manual. There was no change in that manual. So we're going to go through them here. And the first category is problems maintaining proper lane position. Now, you've indicated that you saw weaving across lane lines and the straddling of center lane marker, right?
Yes.
But you've also agreed that that doesn't show up on the video.
Yes.
He didn't have any problems with a wide turning radius, correct?
Correct.
Didn't almost strike a vehicle or object,
No.
not even when he pulled off the road.
No.
Wasn't swerving.
Weaving.
We already talked about weaving. Wasn't swerving, right?
No.
Okay. Wasn't drifting. Right?
It's hard to distinguish between all 3 of those, but I mean,
NHTSA does distinguish between them.
I know, I'm saying personally it's hard to distinguish the major differences in those 3, but yes.
Okay. And he was drifting or he wasn't?
I said I don't, it's hard to distinguish.
Your Honor, I'm going to
Swerving
object,
and-
and I'd ask for Mr. Cremines to define the difference between weaving, drifting, swerving, and then maybe he would be able to answer the
He
questions.
testified that he was trained on it, Your Honor. I would think that the trooper would know the differences.
It's really not that helpful to the court to decide if there was a reason to stop him. I mean, it's semantics, mostly,
Sure.
in my opinion.
Didn't have any stopping problems with stopping his vehicle, right?
Other than the 30 seconds, no.
Okay, and that's not listed anywhere as an indicator, correct?
Well, I think it would be lumped in with stopping his vehicle, yes.
He didn't accelerate or decelerate rapidly,
No,
wasn't varying speeds,
no,
wasn't driving lower than 10 miles an hour below the speed limit,
no,
wasn't driving in the opposing lane,
completely in opposing lane, no.
you testified that he responded to your traffic signal in 6 seconds, that would be normal, right? He wasn't slow to respond to any traffic signals,
No,
had his headlights on,
yes,
didn't stop in the lane of traffic.
no,
He signaled consistent with his driving.
yes,
Immediately, there wasn't a right out of the gate appearance of impairment, right?
physically, no. Or with his driving, which one?
Physically.
Other than the odor of alcoholic beverage, when I first made contact with him.
Okay,
He wasn't slurring speeds or anything like that. So,
okay. He wasn't driving on any other than a designated roadway,
no,
so he wasn't driving off the road, like completely off the road.
no,
Didn't make any illegal or improper turns.
no,
Didn't make any improper or unsafe lane changes that you witnessed.
no,
No other inappropriate or unusual behavior.
no,
Wasn't following anybody too closely.
nope,
And then after you flipped your lights on, he didn't attempt to flee, right?
no,
There wasn't any situation where there was no response to emergency equipment.
no,
Testified you believe that there was a slow response to pull over, right?
yes,
But you'd indicated that 6 seconds to acknowledge you within that time frame would be appropriate, right?
yes,
Okay. Didn't make an abrupt swerve after you,
no,
didn't make a sudden stop,
no,
didn't strike a curb or another object or make any new violations.
no,
Okay. So at this point, you approached, after conducting the stop, you approached the vehicle.
yes,
And you went to the passenger side window
yes,
and you had asked Mr. Wynn some divided attention questions, right?
yes.
Okay.
Yes,
So you asked him for his license,
yes,
didn't ask him for his registration proof of insurance.
mhm,
He provided the license to you, right?
yes,
Didn't have any issues doing that.
no,
Didn't hand you a credit card, nothing like that.
no,
Now, you had indicated that you were unsure of whether you could tell whether he had bloodshot eyes at the time you approached.
right,
Now, you would take a look, you don't have to read it, but you would take a look at the first portion of the summary, statement of facts, refresh your memory.
okay,
Okay. During the initial portion of the stop, according to your narrative, you don't indicate that you observed bloodshot eyes at that time?
Right.
Okay. So, and it would probably be axiomatic to say, but at this time, Mr. Wynn's not under arrest, right?
Correct.
So, let's kind of go through some of these indicators for phase 2. Now, NHTSA has said that phase 2 is the only section that the officer has to perform, correct? So, at that time, you didn't indicate that you would observe bloodshot eyes at that time, right?
Correct.
You didn't see any soiled clothing,
No.
no fumbling fingers,
No.
no alcohol containers,
No.
no drugs or drug paraphernalia,
No.
no bruises, bumps, or scratches,
No.
no unusual actions.
No.
You didn't forget to produce documents while you're dividing his attention.
Correct.
Didn't produce the wrong documents.
Say it again, I'm sorry.
Didn't produce the wrong documents.
Correct.
Didn't fail to see his documents.
Correct.
Didn't fumble or drop his wallet or the documents or anything like that. And he retrieved it with his fingertips, right?
Yes.
Okay. Now, you testified that at that time, he didn't have any slurred speech, correct?
Correct.
Matter of fact, I believe you had indicated that the speech was normal,
Correct.
and that was throughout the stop.
Correct.
He didn't give you any inconsistent responses.
No.
He did admit to drinking a glass of wine.
Correct.
Didn't make any unusual statements that
No.
at that point, and he wasn't using any abusive language towards you.
No.
You indicated you smelled the odor of an alcoholic beverage coming from the vehicle.
Yes.
There were no cover-up odors, marijuana, or any other unusual odors that you noted.
No.
And when you exited the vehicle, you're trained to look for 7 exit for the vehicle, possible cues, correct?
Okay.
Did you see any angry or unusual reaction?
No.
Did he follow your directions appropriately?
Yes.
Didn't have any issue where he couldn't open his door?
No.
Didn't leave his car in gear?
No.
Didn't have to climb out of the car?
No.
He didn't need to lean against the car as he's walking back?
No.
And he didn't have to keep his hand on the car to steady himself?
No.
So at that point, he's walking normally, correct?
Yes.
He's talking normally,
Yes.
just as a normal individual would, that you would see at a traffic stop.
Yes.
You never indicated that he had any type of flush face.
No.
And at that time, you didn't ask him any further divided attention questions, correct?
Okay.
After you got him out of the vehicle. Is that fair to say?
Yeah.
Okay. Now, at no point during this time frame did you ask him about any type of medical conditions he had?
I believe up to this point.
Correct.
Okay. Yeah. Up to this point, yes. But I believe I did ask him if he was taking any medication.
Okay.
For anything.
I agree with that later. You did ask him about medications.
Yeah.
But at this point, you hadn't asked him about any possible medical conditions that could mimic impairment.
No. I got to that yet.
Okay. So you didn't ask him about any type of disabilities?
I believe I asked him if he had any leg or back injuries or anything like that, I believe, which I normally do.
Okay. Was that after you, in the field sobriety battery?
Normally I ask people before I have them perform any field sobriety exercises.
Okay. You would agree with me that phase 3 includes field sobriety battery, correct?
Okay, yes.
Pre-arrest screening.
Yes.
And as part of that, NHTSA indicates that you have to ask them about, qualify them to make sure that they're good candidates for the test.
Okay.
Is that fair to say?
Yes.
And that's when you ask them
Yes.
some of those questions.
Yes.
Would you also agree with me that NHTSA during phase 2 indicates that you can ask them medical questions?
That I can or I have to?
That you can.
Okay.
And
Does it say I have to though?
does not say you have to, I'm saying that you can, right?
Okay.
And you would agree with me that those would also be further divided attention questions that you would be asking?
Don't know if it would be divided attention, I'm just asking a question, but yeah.
Okay? So at that point, did you ask him about any disabilities?
At that point,
Yep.
no, never did.
Did you ask him if he was sick or injured?
No,
If he was under the care of a doctor or dentist?
no,
That he was diabetic,
no,
epileptic?
no,
At that point, taking any medications, and I know you did later, is that fair to say?
yes,
Did you ask him about any head trauma?
yes.
At this point, did you ask him
Oh,
about
no.
any?
Sorry.
Okay. And did you give him any of the additional 3 techniques that NHTSA gives the officers that are non-standardized field sobriety tests, but they're divided attention tasks?
No, I did not.
Okay. That would be the alphabet, countdown, and finger techniques.
Correct.
So, at this point, once you had him out of the vehicle and you walked him back, at that point, you began talking to him about medications and the like.
Correct.
So at that point, you're in phase 3.
Correct.
Okay. Nothing further, Your Honor.
Anything further?
I just have a couple questions, Your Honor. Trooper, Mr. Cremines asked you several questions relating to what you didn't see.
Right.
And there's I guess a number of these that are set forth in the NHTSA manual, things to look for.
Correct.
Are you limited to those things on the list?
No, those are just the set things to look for. There could be some other indicators that are listed on there.
You're familiar with the 2018 manual?
Yes.
And I'm here on session 5, page 7 of the 2018 manual.
So I know where you're.
It's this thing about the 100 Qs reduced to 24.
Okay.
So I'm going to have you just read about 5 lines here, starting right here.
This is also research to identify the most common and reliable initial indicators of DWI. Research identified 100 Qs, each providing a high probability indication that the driver is under the influence. The list was reduced to 24 Qs during 3 field studies involving hundreds of officers and more than 12,000 enforcement stops.
Did anybody in your training or anywhere else ever tell you that you were just limited to the ones, the Qs that are
No.
found in the book?
No.
That's all I have, Your Honor.
Just briefly, you aren't familiar with what those 100 Qs are, correct?
No.
Matter of fact, you're not trained on them, right? And what you just read, it was indicated that based upon the field test, that those Qs were reduced down to 24.
That's what it says.
Okay, so would you agree with me that based on what it says is based upon research, they narrowed the indicators to what they believe are validated indicators?
That's not what it
I believe
says.
they're all
I object to that
validated.
question.
I'm guessing those are the most common.
So, and just to repeat what you said that you're guessing those are the most common?
I think he sustained the objection.
I sustain the objection.
Okay. Well, so one more time, you're not sure what any of those indicators are? The 100 indicators?
All of them? I'm going to list them all? No, I can't do that.
Okay. Nothing further.
It's,
Sit down.
we rest, Your Honor.
Likewise, not calling any witnesses, Your Honor.
Okay. So I'm assuming we're going to get briefs on this too.
Which the good news is this brief will be very similar to the brief that I'm presently writing. So
Okay.
it's the same issue, so.
So it appears to me from watching the video myself, the vehicle is moving within the lane. I cannot say from the video if the tire went over the line or didn't go over the line. So does that make a difference? Do I have to only go on the evidence presented in the video? Do I have to discount the officer's testimony that he could see that the tire was over the line? I'm not allowed to consider that. So there's something for you to brief.
Actually, Your Honor, I could probably save the court some time. That is entirely up to the court and based upon the court's judgment of credibility in viewing the evidence that is there. That's for the court to determine. There's not going to be any case law or anything dealing with that other than that says that it's the court's determination.
All right. So it's a credibility issue with the court as the witness.
Correct.
We believe
that would have been my initial inclination, but I didn't know if there was case law or something out there that said otherwise. So we've got testimony that we've got a strong odor of alcohol and admission of drinking 1 glass of wine before leaving the vehicle. Is that sufficient to get someone out of the vehicle?
It is to get out, Your Honor, presently in the state of the law, because they can ask out of the vehicle for any reason. I think the more appropriate question would be is that is sufficient to conduct field sobriety testing.
Well, we got another factor to add after he gets out of the vehicle, bloodshot eyes. That
And also
testified to after getting out of the vehicle.
the driving too.
Well, yes, in addition to the observations of driving. So those are the things that I'd like for you to address. Seems to me like that's something you both can, I don't know if you need to wait to respond to the other person.
In other words, the question is what he presented as his reasonable suspicion actually reasonable suspicion?
Yes.
I'm not sure that wouldn't be something that would be the court's discretion based on.
I think there's a 4th District Court of Appeals decision that talks about the evidence on, I may get this wrong, going over the fog line sufficient but not going over the yellow line or vice versa. There's a 4th District Court of Appeals decision that talks about which line is which, and they made some distinction between that. I'd like to see that case.
You have to go, it has to be all the way over the fog line on the right, but there's never been a case in the 4th District anyway that, unless you've got, that really talks about the left line. If it's a 2-lane road and there's a yellow line, then if your car is over the line, like even your mirror or whatever, into the other lane, that's a whole different thing than being over on the right-hand side.
The Supreme Court has partly decided that issue, I believe back in around 2020, Your Honor, State v. Turner. And that's what Mr. Hill was, I think, referencing, that the car has to completely cross the fog line. They kind of, the appeal was sought on whether crossing any line was sufficient, and they said, well, in this case it was a fog line, it was touching the fog line. They said touching is not enough, but they punted on the issue of whether it was a center line. But with this being a 2-way, I don't know if that affects it or doesn't.
But it also,
and there's a split between the districts on that.
I think it dealt with a single lane violation.
Okay, see what you can get me on that. And that's whatever else you think is relevant.
I can do that, and Your Honor, I think I'm due to have the other brief done by Monday, and so the cases that I'm citing should be similar, and so I'll try to have that in as quickly as I can around that time as well.
Okay, I'm going to put this on the docket for the 30th for me to review. Do you want to argue it then, or just submit it?
Why don't we do this, Your Honor? I've reserved the right to argue it, but we may just submit it.
I'll set it on the docket. Let's put it down as a pretrial argue motion on October 30th. If you want to show up and argue it, you can.
And if you know, on it, Your Honor, I'm not going to request an argument. I will put in the brief that submitted on brief. That way the court's aware and it's not a surprise.
I think the video needs to be marked too as plaintiff's exhibit 1. I think he
I stipulated, so yeah, I've no issue with that.
Now, does the court, do you want me to do a brief at the same time as him, or you want me to respond?
I don't see why, you know what the issues are, so it's not like it's going to be a surprise. Then if you see something that is in the other brief you want to respond to, I'm happy with you doing that. And if you want to just give me a case, file something with the case name that you think is more appropriate than what the other side has filed, feel free to do that. Okay, anything else?
Thank you, Your Honor.
Court's adjourned.
Don't tell me where he's at. He's on focus on.
Wow, you mean the hall was carrying a pistol?
Yeah.